This is the application of Madison Gas and Electric Company for authority to adjust electric rates and natural gas rates. We're in docket 3270 UR 125. My name is Michael Newmark, Administrative Law Judge for the PSC, and we are on Zoom. We've had public sessions for receiving public comments on September 6th. And today we're accepting evidence from commission staff and parties. And we're still accepting written comments up until Tuesday, September 26th through the internet and by US mail. And details on doing that are on the notice of hearing, which is being displayed now on the screen share and available on the commission's website. So let's just do appearances. Go through our service list, and I think there may be one person at least that is well, we gotta let more people in here. One person at least that's not on the list, not the list that I'm showing here. And we'll just have to take care of that when we get to the party that the person's affiliated with. Unfortunately, it's skipping my mind, so we'll have to just go through the list and correct that. Representing 350 Wisconsin.
Your Honor, Dan Gustafson of Midwest Environmental Advocates for 350 Wisconsin. And I currently have both of my witnesses on the line, but if there's no need for them to remain, they will drop off.
Okay, yeah, let's get through the list and then we can, we'll do the witness list as after that. So Blacks for Political and Social Action of Dane County, who's representing them?
Good morning, Judge Krista Westerberg of Feinsbach here for BPSA.
Okay, Board of Regents for the University of Wisconsin System.
Morning, Your Honor. This is Lissa Coop on behalf of UW-Madison.
Morning. Charge Point. Do we have someone representing Charge Point?
Your Honor, this is Brian Kleinmeyer for MGE. I believe ChargePoint withdrew.
Yeah, I agree. I think this list is out of date, unfortunately. Wondering if this is the list I even shared before, because I know I updated that. No, they're still on there. Okay, we'll have to make a note of that. Okay, so Charge Point's withdrawn as party. Citizens Utility Board.
Good morning, Your Honor. Kara Coburn Ferris for CUM.
Okay, and City of Madison.
Doran Visti for the City of Madison.
City of Middleton.
Morning, Judge. Matt Frank of the firm Murphy Desmond appearing for the City of Middleton.
Yeah, there was, I don't know. Trying to come up with an acronym for both City of Madison and City of Middleton. Okay, and Dane County.
Good morning, Assistant Corporation Counsel Cricket Beeson on behalf of Dane County.
Okay, thanks. IBEW Local 2304.
Good morning, Your Honor. Brandon Cosgrove representing IBW Local 2304.
I missed a few people there. I didn't see you come up there, but I heard you for sure. So Elevate.
Good morning, Your Honor. This is Ann McKibben representing Elevate.
Okay, local. Madison Gas and Electric.
Your Honor, Brian Kleinmeyer, Stafford Rosenbaum for MGE.
Public Service Commission.
Zachary Peters on behalf of the PSC, Your Honor.
Renew Wisconsin.
Good morning, Your Honor. Kim Lindell from Keys and Fox on behalf of Renew Wisconsin. And along with me, who will also be speaking today, is Grant Snyder, who needs to enter an appearance but is currently listed as PSC staff.
Okay. Maybe I'm clairvoyant. I don't know. Any desire to work state service? Don't laugh too much.
I mean, usually the poaching of our people takes place behind the scenes and not in the hearing on the record, but hey.
Usually the poaching doesn't go that way. I'm just trying to find you on my list here. Should be listed with PSC. Seeing. Well, when he's speaking, we'll have to change that because I'm not.
Your Honor, would it be helpful if I spoke and I don't know if I elevate to the top of the list or something?
No, it doesn't seem to be working like it should, but I'm gonna just highlight the speaker. Okay, well, there you are, yeah. Great. So Renew, is that right?
Correct.
I'm gonna make the mistake twice. Okay, great, thanks. Sierra Club? Thought I saw David Bender here.
He's on the screen, but and not muted.
Okay, we're not hearing you for some reason.
Oh.
Okay. Well, Attorney Bender, can you test out your audio? Any luck? Okay, we'll have to return to you. SCIA.
Morning, Your Honor. Nikhil Bajaker from the law firm of Keys and Fox on behalf of the Solar Energy Industries Association.
Great, thanks. You are tricky to remember who you're representing. So I'm glad you did that for me. Thanks. And Vote Solar. It's here for Vote Solar.
Your Honor, that should be Mr. Bender again.
Oh, right. Yep. And there's no co-counsel for, I thought there was co-counsel. Walmart.
Yes, good morning, Your Honor. Barry Naum and Stephen Lee from the law firm of Spellman, Thomas & Battle, representing Walmart, Inc. And Mr. Lee will also be speaking today.
Okay, yep, thanks. WIG.
Good morning, Your Honor. Steve Heinzen for WIG.
And Wisconsin Local Government Climate Action Coalition.
Yes, good morning, Allison Carlson from WLGCC.
Thanks. Okay, so I think our only issue may be with Attorney Bender's connections. Let's go off the record and just investigate that a bit. Yeah, I know I saw him. He's on the list. And Debbie, your phone is ends in 179, right?
Correct.
So I don't know if Attorney Bender, if you can hear me, you're free to call in if you're not able to.
Your Honor, this is Tim Lindell. Mr. Bender just let me know that Zoom keeps kicking him off and he is trying to reconnect.
Okay, well, he can dial in as an alternative if there's no other way. And that number is on the notice of hearing. Okay.
I don't see a number under the party hearing session for dial-in. Is it the same one as under the public hearing session, Your Honor?
Yes, it's the same. Okay, so while we wait another minute or so, see if we can get David Bender on the line. But in the meantime, just wanted to welcome Commissioners Bach and Huebner to the hearing. They'll be observing and free to ask questions of the witnesses. Also, I think we should just get on at this point and discuss, well, it's going to be difficult without Sierra Club. Huh? Let's stay off the record then and just talk about corrections to the evidence list. Oh, here we go. We'll switch gears again. Okay, there we go. Let's just stay off the record and test out audio here. So it looks like Bender's audio is still connecting. Oh, I do have a phone coming in as well. Phone connection, maybe that'll help. Yeah, see you there, Attorney Bender. Is that your phone connection as well? Well, you'll have to unmute by pressing *6 if you're connecting by phone.
Your Honor, is this a good time to raise a question about your corrections to the offered evidence?
Well, I was trying to see if we could get Attorney Bender on the line here. Then we could talk about witnesses and excusing witnesses. So do we have you there, Attorney Bender?
Yeah, can you hear me?
Yeah, you are a little low. So if you could speak up or possibly get closer to your microphone.
All right. Is that better?
Not by much, but we'll have to, I can raise my volume. Can you hear him, Debbie? You're the person I really want to be able to hear, so.
He's quiet, but I can make it out.
Okay, all right, well, keep our dogs at bay, literally.
No pun intended in my house.
I know. All right, so, great. So I do have a few people, it looked like we had a few people we had cross-examination questions for. And I just wanted to poll the attorneys and the parties and the commission at this point to make sure we can excuse witnesses, there being no cross-examination for them. I did want to mention, and let's get on the record for this. So I did want to mention this process is a little different than normal in that there may be rebuttal coming in live. And so witnesses may want to actually be here to hear that in order to, if we need to recall witnesses or have any supplemental statements in response be given. I was going to allow the recall witnesses in order to accommodate the shortened schedules that we set for filing. And if we do get new testimony coming in live, your witnesses may need or they may want to be here to hear that. So we can excuse witnesses with the understanding that if circumstances change, we can recall them, and but they'll probably need to be online or watching the hearing in order to know what's going on. So just be careful about that. So when it comes to the applicant witnesses, I know we had 2. Possibly 3, but I think 2 at this point witnesses there was cross for. So let me just ask the applicant, do you plan to present your witnesses live?
Your Honor, I mean, to the extent that there's not cross for witnesses, I think that we would just prefer to do it by affidavit by verification to make the process go a little faster. I do have an update on 2 of the witnesses that were identified for cross-examination that I'd like to discuss, and obviously then the other attorneys can chime in. Went for Erin Monroe Nye, who's highlighted on the screen right now. Renew had indicated that they had cross-examination for Ms. Monroe Nye. I did working between MGE and Renew. I think where we landed, and I sent out email this morning 2 proposed exhibits. I sent it to the service list first, and then recognized that Your Honor, were not on that email. So then I followed up with an email to you, copying Mr. Lindell and Mr. Grant or Mr. Snyder. I think at this point, MGE and Renew have agreed that if exhibits 1 and 2 can be entered into the record, then there's not a need to cross-examine Ms. Monroe Nye, but I will defer to also comment from Tim and Grant on that.
Okay, good. Well, let's just deal with that right away then. So Monroe Nye, do we still have questions for that witness?
No, Your Honor, we don't. Renew does not.
Okay, does anyone else? No, okay, I'm just going to take silence for consent here because it's pretty much impossible to go through the entire list. But did want to look at those exhibits now. A little temperamental here. So these are Monroe Nye exhibits. Okay. Let's go off the record for a second here. Rebuttal. Okay. I think is this the one? Okay, so I do recall seeing this. I don't know exactly how. We just got this message, but okay. Then Nye 2 is stipulated facts. So I suppose I think may need some background on those filings, just to put them in context with the with our case. Is it, so I would suggest we have witness Monroe and I just take the stand and give us a brief explanation of what we're going to be receiving here.
Well, if Your Honor, I mean, we can certainly do that. I mean,
yeah.
If you go, Mr. Lindell had sent an email out yesterday when he had indicated that he was going to cross-examine Ms. Monroe and I, and he had attached this the testimony from Ms. Irwin, and then we had few additional discussions, and MGE stipulated to including this exhibit, and then MGE proposed 5 facts that we believe are somewhat relevant to some of the testimony that Ms. Irwin provided in the NSP docket, and that's essentially how we landed at this spot.
Okay, I see. All right. Yeah, that's fine. I think we do want to just have a bit of a background, just so we have a trail on the record where this is coming from and why. I think it would be useful just to have the witness explain that briefly, because I guess I'm not, the stipulated facts in particular, I'm just not sure. Well, I'm just gonna let the company just explain that to us on the record. That would be useful, I think. So we'll count on witness Monroe and I taking the stand for a bit. And was there another witness you wanted to discuss as well?
Yes, Your Honor. My understanding is that.
I want to make sure we're on the record now.
Go ahead.
Let's get on the record now.
I guess 2 other witnesses I just want to comment on, notwithstanding the fact that I don't think he's been identified as cross-examination. Witness Martin Smith, we're going to call just for essentially the standard verification of testimony, and then 1 Q&A responsive to rebuttal testimony that was filed by Mr. Kenworthy on behalf of Vote Solar and Sierra Club on Friday. And actually, I'm going to have to get to that issue too. There's actually 2 different Smiths in this docket. We'll explain it.
Oh, yes.
Last thing that I would say is my understanding is that commission staff no longer needs to call on Mr. Weinert for cross-examination. MGE was able to file a data request response yesterday in response to a data request from Mr. Ritzema. And obviously, Mr. Peters can confirm, but my understanding is because that data request response was filed, it's no longer necessary to cross-examine Mr. Weinert.
Okay.
Yes, Your Honor, that's correct. Commission staff will instead update the staff data request response exhibit pursuant to the facilitating matters, and I can touch on that as well when that exhibit is discussed in direct verification testimony.
Okay, great. I'm just going to note that here. So, and then the other witness I think we had pending for questions was Pennington. Are we still calling that witness?
Yes, my understanding is there's still cross-examination for Mr. Pennington, so we will call him.
So it looks like for the record, we can accept testimony from the applicant by affidavit. For witnesses, Bates, Billings, Deneau, for Garcia, Sierra, Minor. We'll have Roan, Schmudlock, and Weinert. And the other witnesses will be appearing to verify testimony.
And then also, we did have a few comments regarding the offered evidence. I'm not sure if you want us to go through those, but one of the other witnesses that would be verified through affidavit would be Scott Smith. We have Scott Smith and we have Marty Smith. we weren't sure how to address the Smiths in the testimony, and so I apologize that it's created confusion, but I can, if you look at the offered evidence list that you have right now, the direct testimony is for Scott Smith, rebuttal testimony, and the two exhibits are for Martin Smith.
Okay. Well, that's my oversight as well, so that's fine. I think probably, I mean, it only probably confused me as far as I know. But and the exhibit you said was for Martin Smith.
Correct, Your Honor.
Okay. So we will be excusing Scott Smith as well. Okay. All right. So we already asked that. Okay. So for 350 Wisconsin, any questions for the witnesses there? So we can excuse Greenler and Hatchen, and they can file affidavits to verify testimony.
Your Honor, one quick question about clarification. If we're filing corrected testimony and exhibits.
Okay, can we wait on that and go through the witness list first? Yeah, before we go through more corrections. Thanks. So BPSA witness Colton, were there questions for that witness? No? Okay, we can excuse him. Board of Regents Hanson, any questions? We'll excuse two. For Cub, Callan, any questions? Time. Singletary. Okay, we'll excuse them. For City Madison, Price. No. Robigo. Well, they're excused. City of Middleton, Hilliard.
Your Honor, this is Matt Frank for the City of Middleton. It's Hilliard.
Okay.
And I was going to mention that there's a CH ended at the end of her name that should be taken off. So it's just Kelly Hilliard.
Okay, so it wasn't just my mistake in pronunciation. Okay. Yeah, I think that, okay, I'll have to look into our system for that too. It was more of a tongue twister than I needed to make it, or less of a tongue twister than I needed. So any questions for Hilliard? And I'm also assuming they're not appearing to verify testimony. We're excusing them or to make an additional statement. Dane County, Kuntz. Questions? Elevate, Archbell. Local 2304, Cosgrove. Renew, Bailey. Kell. Sayu, Vickerman. No questions. Okay. SCIA, any questions for White?
Excuse me, Your Honor. Apologies. Tim Lindell for Renew Wisconsin.
Yes.
Mr. Sayu would prefer to be able to verify his evidence at hearing today instead of issuing an affidavit, if that is okay. It's his first hearing, so he wanted to be able to speak if that works.
I welcome that. Thanks. Okay, so we'll go back to White. Any questions?
Your Honor, this is Nikhil Vijayakar on behalf of SIA. I don't believe anybody has questions for our witness. Our witness is online and so able to verify her testimony live if that's an opportunity before cross-examination begins. If not, it would be fine for us to just submit an affidavit, whatever you prefer.
Okay. Well, we're going to go through the offered evidence list. If I forget remind me and we can call witness White first.
Okay, I appreciate that. Thank you, Your Honor.
So, yeah, sure. So Vote Solar, Kenworthy. Walmart, Kroner. Teague, no questions. Okay, they're all excused. We're just going through the list here. I haven't said they're excused for a while.
I'm sorry,
yes.
Your Honor, real quickly, Steve Heinzen here. Did you just mention Weeg?
Not yet. We're getting
Okay, all right.
So next witness is Stevens. Any questions for Stevens? No?
With Your Honor, with respect to Mr. Stevens, we would like to file his affidavit to verify the testimony, but he has a single correction in his testimony. Can we file errata and then affidavit to verify?
At this point, I'd like the person to state that on the record because we won't be able to see that correction. Is it substantive or?
It's a number.
Yeah, I think we'll need that to come in through the web.
Okay.
Yeah.
Okay, thank you.
Just in case there's any confusion. So, all right, so we'll take Stevens. Okay, so we have commission staff. We have Clark. Any questions? Heider. Griffin. Horry.
I'm sorry, what was that last one?
Oh, Horry, Horri.
Oh, Horry. Okay, thank you.
Ritzma. And Tierney.
Your Honor, with regards to commission staff, I just wanted to confirm that commission staff intends to verify their testimony on the stand today, all of them. And then I would also ask, though I'm not sure that it will be an issue timing wise, that witness Ritzema be able to take the stand before 4:30 today, if possible, if we go that long.
Okay, well, I'll make a note of that. Hopefully I won't need to remember.
Thank
All
you.
right. So let's go. So all the witnesses that we've excused can disconnect and they can file verifications by affidavit. They're not required to do so. They may stay on, they may observe the hearing, and the parties may call those witnesses to verify if they wish. If they change their mind, that's fine. And remember, witnesses still may be recalled in case new issues come up, although I don't think there will be now. So we'll see. Okay, so let's go through the offered evidence list, the details. We can go off the record for this. So are there any questions? We'll start with the applicant. Any questions about the filings?
Yes, Your Honor, just a few. So for example, for Bates, that should actually be direct MGE Bates as opposed to Roan there. And I have the PSC reference number for you. It would be PSC reference number 466609 is Michael's direct testimony.
Okay.
And then I think you'll be able to cut and paste the reference to MGE Roan there and plug that in for her direct testimony down on page 2.
Okay, I see. Yeah.
And then we have Mr. Janu filed a revised Exhibit 5. I'm not sure if that needs to be identified on the offered evidence list, but it's.
Yeah, I have
you have it on there now. Okay.
Excellent. So this version may be updated since the one you guys have received.
Okay. I think that may then apply. Mr. Pennington had also filed 2 revised exhibits, so I'm guessing they're on there now. Yep.
Those, yeah, 13 and 17.
And then for Mr. Schmudlock, you do have the revised testimony identified on the list. So the revised direct effectively took the direct testimony that Mr. Schmudlock had filed, and then I can't tell on this is Exhibit 2 crossed out. He took Exhibit 2 pursuant to commission's request and incorporated exhibit 2 into the direct testimony, which is why we filed the revised. And so I think that essentially the revised direct testimony effectively replaces the initial direct and exhibit 2.
Okay, right. Okay, I remember that now. Okay, thank you.
And then you already addressed the Smith's issue. So I think the applicant is now covered.
Okay, great. So I did want to just touch base and say that, and just to make sure, let me just check, because this isn't something, this is kind of a practice, an unwritten practice. So when you are refiling exhibits, I guess we expect that the email you use to serve those exhibits does explain whatever changes were made. I just want to make sure everyone is doing that, understood.
Your Honor, and I there was an email that was sent by administrative staff to MGE for the revised exhibits for Pennington and Denew, and then I do believe that I did follow up with a reply all email to all parties explaining the changes that were made.
Okay, yeah, just making sure we all remember to do that, because we have some new people here, and okay, so it looks like we have the applicant handled. So we'll move on. Doesn't look else. We had some comments for 350 Wisconsin. Any questions there?
Your Honor, I just wanted to confirm we had some corrections to make. They're not substantive changes to the testimony or exhibits. They're, citations and page numbering and things like that in response to your comments. I assume that we should refile the testimony and exhibits, and that the affidavit of verification should then refer to the refiled documents, correct?
That's correct. Thanks for raising that issue. Yeah, so I did try to give people an advance notice of those the comments so that you could incorporate those concepts into rebuttal and surrebuttal. I apologize if that may have confused people, because I usually wait till the very end to give you all of the corrections, but there's so many filings that I was hoping to nip some of the repeat mistakes in the bud. But I think the instructions said to wait for filing corrections till the end, and I appreciate people who've done that. But in terms of in terms of the corrections that I've identified, they didn't need to be put into an errata, because we all understand, we've already seen where those corrections are going to be. If you had additional corrections, they should have been filed before the hearing in an errata. So I guess you mentioned that at least some of the corrections were the comments that I had made. Are there additional corrections?
I don't believe so. I think they're all to address your comments, and they're not substantive changes to the testimony.
Right. Yep. Okay, good. Yeah, so just file those. I guess we might as well take care of that pending motion too. So let's get on the record. We're not there already. So I think it was Renew that did file to ask for an extra few hours, I think, to file the errata. I'm sorry, the refiled corrected exhibits and testimony. I think the deadline was Friday at 1:30. I think they wanted Monday at 3:30. Am I explaining that correctly?
I think that the deadline was yesterday at 1:30, Your Honor.
Oh, no, that's okay. So that's where the confusion is. Okay, the errata was due before the hearing. The corrections now are due after the hearing. So at this point, the errata is moot. That should have already been filed. Corrections, and I think what Renew had done is include the errata and then a red line version of their corrected testimony. So for Friday, we're going to need just a clean version of the refilings. Those will be the documents we accept for the record. So that's been our standard practice: errata before the hearing, and then corrected final versions after the hearing. So I think you pretty much have them all the corrections identified already. So probably filing it Friday won't be too difficult, I hope. So we can keep the schedule as it is. Okay, so any questions about that? Okay, so we go off the record again. So let me just open this up so we don't take all day. Is there any other questions about the comment list? Okay, looks like Walmart.
Your Honor,
Yes.
Okay, let me take Walmart first because they had their hand. They're using their hand. We don't usually do that, but that's fine. Go ahead.
Yes, thank you, Your Honor. Two questions that I had emailed to Your Honor yesterday and copied all the parties. The first is the reference to citation disclaimers. Just we've looked to try to figure out what was meant, and we apologize. We're somewhat new to practice before the Wisconsin Commission. So if you could just provide a clarification on that. And then secondly, and I don't want to make more of this than I should, Your Honor, but you also had indicated that we needed to make a substantive revision to both statements of testimony, removing the word additional. It's just irregular from my experience to have a bench directed change to substantive testimony. It is, in this case, not a problem at all because it is immaterial to the substance of the testimony, but also just wondering if Your Honor could provide a rationale and clarification for that change as well.
Sure. So I did invite questions on my comments when I sent the email out on September 5th, and did receive a number of questions that I was happy to answer. But I can address that now. So yeah, I mean, I don't know if it's substantive or not, but I think I have Kroner's page 1 on the screen. So the question is Walmart sponsoring additional testimony in this docket? As far as I know, this is the first time Walmart's filing and the witness is making a filing in this docket. So I don't think additional is appropriate, and it seems to be confusing to me. I don't know if that, maybe I'm off base here, but I just didn't want to confuse the record by having the statement additional testimony. And then we're looking for the previously filed testimony.
I see, Your Honor. I think what we had intended with that and what the witness had intended was to indicate that there was more than one statement of testimony being offered by Walmart. So in addition to Mr. Kronauer, there's also Mr. Teague's testimony. So again, it's immaterial, I think, to the substance of the testimony, but your explanation is certainly fine with me. If it confuses the procedure, we'll certainly be happy to make that change.
Yeah, I mean, I see what you're saying now. I guess I wouldn't include, I don't know if it's really necessary. Yeah, okay, you can leave it as it is.
Okay, thank you, Your Honor.
And then in terms of citation disclaimers, see, I have page 3, footnote 1. It's basically the Walmart website, I believe, is what you're citing. So, you know, this is a new process for us. So, I mean, reminding you about this, I think we all can use a primer on this, but so it was prior to these cases, the IOU rate cases, this sort of citation was not allowed without killing the site by physically changing the letters and the combination of letters so that you couldn't click through. And we all found that pretty taxing exercise. The facilitating matters order in this case was changed to allow citations as long as after the citation there's a disclaimer that says this citation is not record evidence, so that the reader will know that clicking through this site does not present evidence on the record that the commission can use to make a decision. So that's our compromise to avoid the manipulation of websites and hyperlinks, and really any citation except for publicly available legal citations. Every citation that you're not introducing into the record proactively by offering it as an exhibit should have that disclaimer on it, so that we have no confusion about what's in the record and what's not, but also allow people to include cites to assist parties and witnesses to see where sources are coming from, including having a hyperlink. That's it's okay. Under most circumstances, I think there were some that just caused some confusion in the text of the document, but this one's okay as long as we have that citation disclaimer following after the link.
Okay, thank you, Your Honor. Really appreciate that. That provides great clarification for us. Thank you.
And that direction is in the facilitating matters order. So you'll see that attached to the scheduling order in case you need to look back to it.
Okay, thank you, Your Honor.
Okay, good. So Cub, did you have questions on?
I did, Your Honor. With respect to witness Callan's Exhibit 5, you had asked that we file a confidential version of that as well. And it's that is a little bit confusing. That is not confidential data. We just meant to focus on we were presenting information on how to demonstrate the historical accuracy of fuel forecasts. So we were looking really more at the format of that Excel spreadsheet and not actually the data that is there. So I think what we'll do, if it's acceptable, is just revise that exhibit to clarify what we're presenting there, and then we will just file it as a single exhibit 5R.
Okay, so just an explanation right on the exhibit.
If that's acceptable.
Mm-hmm. Okay, yeah, that's fine. Yeah, that definitely. And I was looking for the confidential version. I couldn't find it, which is why it's even more confusing to me. Okay, great. Thanks for that. Anything else from Cub?
That's it. Thank you, Your Honor.
City of Middleton.
Yes, thank you, Your Honor. Just another follow-up to the citations are not record evidence matter. Slightly different scenario, I think you raised with the City of Middleton, going to Kelly Hilliard's testimony in exhibits 8 and 9. Those exhibits were not prepared for this litigation. They're City of Middleton documents, and they happen to include references to web links and so forth. So I guess my question is it sufficient? There is a cover page for each of those exhibits. When we refile, can we simply on the cover page make a notation that citations in this exhibit are not record evidence? Otherwise, we have to go back through a previously prepared city document and somehow amend it. And that would be very time consuming and somewhat repetitive if we could cover it on the exhibit face.
Okay, yes. And you're very wise to suggest that, because I've already put that in the facilitating matters order as the process to use. So when you're in an exhibit like that, you just need to put the disclaimer right on the cover page, and that covers everything else within that exhibit. And to that point also, we don't want people to disturb a pre-existing document. So I've seen a number of those. I think everyone understands that now, but just because it relates. So to put in the disclaimer now would be against the process to not disturb an existing document. So if you were to change the document at all, I'd be kicking that back to you and saying, don't do that. So yes, put the disclaimer on the cover page. And if you're introducing a document that already exists and wasn't prepared for the docket, then you just want to keep that in the order that you found it. So you may have a document with a marking on it, but that's the one you have, so that's okay. But if you wouldn't want to add any marks to the document in order to file it, like putting the exhibit number on the page of the existing document, or putting a page number on the existing document. We don't want to see that. We just want to see the original, to the extent you have the original. So I hope does that clear up the question?
That does, Your Honor. Thank you.
Okay, perfect. Thanks. Looks like Elevate.
Thank you, Your Honor. I have a quick question about the comment to our exhibit. This is our first Wisconsin PSC proceeding, so I want to make sure I understand. the comment was to remove all the exhibit marks after 1. And am I correct that that's because we have some page numbers that look like exhibit numbers?
It's on the exhibit, yes.
Yeah.
Right. So I think similar to what we were just saying, these are existing documents. Oh, these aren't existing.
No, they're new.
Okay, maybe that's not so. Oh, yeah, well, okay, so yeah, that's confusing because that makes it look like that's exhibit 2. I mean, that's as simple as I can explain it.
I think I understand. Thank you so much,
So
sir.
just keep that off. That would be fine. Yeah, thanks.
Right, will do. Thank you.
Mhm. Anyone else on the offered evidence list?
Your Honor, for Renew, I was not sure if you had noted the updates that we made yesterday at around 3 p.m.
The errata, is that what you mean, or something
Yes,
else?
the errata, correct.
Okay. So, okay, I'm sorry. I thought we discussed this already. Okay, so yeah, I didn't put it on the list because but I understand you filed it. So I think if you can just file the final versions. It was just too late to put it in there in my version. But if you could just file the final versions by Friday, that would be great.
Understood. Thank you.
Mm-hmm.
Your Honor, one more question for Renew, if you will, please.
Yes, this is Tim Lindell.
Tim Lindell.
Okay, great.
Thank you, Your Honor. Yeah, Tim Lindell for Renew. Either I made a mistake in misremembering prior commission practice here, or something changed that I missed here. Our typical practice is to always take data request responses that we got that we will use in our testimony, put them together in an exhibit and attach them to an exhibit. We did not do that in this case because I had thought that we weren't supposed to. And I think that I misremembered that. And I think that I misread the facilitating matters order along those lines as well. The reason I caught this was because of a comment you had made on Mr. Vickerman's rebuttal that said you need the disclaimer here because this is not record evidence. Our intention was very much to have the data request responses that we got back from Renew or from MGE included as record evidence. So I am trying to determine the best process to go to attempt to remedy that. And we can either submit this as part of what we're going to submit on Friday, or we can follow the post-hearing procedures and request leave to present additional evidence. And I'm just wondering Your Honor's thoughts on the best way to proceed at this point.
Okay, so let's get on the record and just have you make the request to do that. If you could just detail, we don't need the PSC numbers, but if you could just detail the context and provide just a description of what you're talking about. I think we won't get any objections. We've already identified those documents. We'll just put them in the record today and then have your file by Friday.
Okay, thank you, Your Honor.
So when we're on the record, go ahead, Attorney Lindell.
Thank you, Your Honor. Tim Lindell for Renew, Wisconsin. Renew made a mistake in interpreting the facilitating matters order and utilizing or misremembering prior practice at the commission. Our intent was certainly for all of the data request responses we received from Madison Gas and Electric to be record evidence in this case. In our misinterpretation, we did not collect all of those data request responses and put them into exhibits that would be attached to the different pieces of testimony in which those exhibits are referred as part of an exhibit for each witness. And so, Your Honor, we would request leave to be able to do so and to add an exhibit for each witness that would include all of the data request responses that are referenced within each witness's testimony.
Okay, and then I'd assume that you'd refile the testimony to recite to the exhibit.
Yes, Your Honor, we would file a corrected version of the testimony that would then cite to those new exhibits, please.
All right. Any objections to that?
Just to clarify, the Renew is only going to be filing the discovery responses that have already been referenced in the testimony. It's not going to be additional discovery responses. I think that's what you said, Tim. I just want to make sure.
Yes, Your Honor, Tim Lindell for Renew. That's exactly right, Brian. Yeah, that's the idea. Certainly not trying to introduce anything new at this point, just the ones that are already referenced in the testimony.
No objections, Your Honor.
Okay. All right, thanks. So we'll just add marking to, so each witness will need an additional exhibit.
Yes, Your Honor. I believe the two witnesses that would have additional exhibits would be witness Kell and witness Vickerman. I do not believe witness Sayu or witness Bailey will have additional exhibits.
Okay, so let's mark those Kell 9. Oh, Kell 10, sorry. And Vickerman 10 will be the data request responses from MGE.
Your Honor, can I ask a quick question on that? Then the problem applies to both their direct and surrebuttal. Would you like us to just include all of them in one exhibit?
Yes, yeah, go ahead and do that.
Thank you, Your Honor.
Okay, any other comments on the comments?
Your Honor, it's Dave Bender for Vote for and Sierra Club. You had one on Kenworthy 2, Exhibit 2.
I just want to make sure we're off the record.
We're on the record.
Off.
Thank you.
Yeah, okay. Kenworthy, where do I go?
Kenworthy Exhibit 2, you had what is a question, and I'm not sure if you need us to provide a substantive change to this exhibit. The question was, I think, why only the redacted response? Everything that we cited and used from it is from the public version. So rather than go through the hoops of filing the confidential for no purpose that we needed to cite it for, we just included the public version.
Okay, so you didn't use the confidential version. Yeah, I think that's fine this time. So you're not even referencing these responses, is that what you're saying? The ones that are redacted?
Correct. I think what was referenced was further down. I think it was cut and pasted right into Mr. Kenworthy's testimony. That what you just scrolled past, which is all public.
That's okay. So I mean, I guess one way to handle that in the future is you can include an excerpted version of these documents, so we're not putting in pages that you're not going to be offering or that are not substantive to your argument. So just that's something to think about, but it can just stay the way it is. That's fine. Anything else?
Yes, Judge Krista Westerberg with BPSA. On Colton Exhibit 16, we were instructed to add the disclaimer to the cover sheet to say the citation is not record evidence. I assume that references the hyperlink in the data request response we've attached. I'll let you get there.
I don't know. Let's see. 17, you said?
16. Scroll up to the data request response.
This was attached.
Yeah, an excerpt was attached. So
right.
We also attached that same excerpt as Exhibit 4. So the citation, some pages of it are record evidence, whereas the rest of the report is not. So I just didn't know if it would be accurate to still include that disclaimer, or if we should say it's in part not record evidence.
Oh, well, okay. So I think maybe what I was thinking of is this citation. Is this this was something that was provided by MGE.
That's right.
And that's also offered as Exhibit 4, you said?
Sorry, scrolling up a page, it's not that hyperlink, it's the one on in the written response there.
Yeah.
That is included as record evidence in part.
Okay, so, but it is in Exhibit 4. So I think in that sense, it's on its own in its own form offered for the record. The citation is not offered for the record.
Okay.
Okay, and then I think it also, the disclaimer is also going to apply to this citation as well.
Okay, we'll do it. Thank you.
Anyone else?
Yes, Your Honor. This is Nikhil Vijaykar on behalf of SIA.
Okay.
I have a couple questions prompted by your discussion with some of the other attorneys during this session, and I appreciate your clarification. In our witnesses' testimony, we reference several data responses, and consistent with our past practice, these are documents that have been filed on IRF, so we just included PSC reference numbers along with our citation. We didn't hyperlink the PSC reference number, but the PSC reference number is in the document just to serve as a source for the assertions that are made in our testimony. Now, I don't know if your preference then is for us to separately include the documents, the data request responses as exhibits, or if it's sufficient for us to include those just as sources, and then we have the matters asserted in the testimony as the evidence itself.
Okay, yeah. Well, the comment was to add the disclaimer, right? That's what I was. So the various pages add the disclaimer, and those I believe are the citations to the data request responses. That's what I'm asking. I mean, I think what happened with Renew is intending to submit those data request responses for the record. So I allowed it without objection. It didn't appear like that was your intent with the white testimony. It's certainly appropriate to cite to a document that the witness used as background. But now, according to the new process, so recall, and you might not have been involved when this happened, but the scheduling order went out. Prior to the scheduling order being finalized, I sent out a red line version of the FMO indicating that particular change, that if you're citing to something, put in the disclaimer, but you can use PSC reference numbers, you can use hyperlinks. I'm not going to be editing all of these filings anymore. You just need to put in the disclaimer so that the reader knows, hey, this is not record evidence. I can't look at it for the basis of my decision. The witness can cite to it saying, this is the basis for my statement, my expert statement. That's fine. But so that's why, following up with the new FMO direction, I was just following up and asking you to add that disclaimer. Now, if you wanted to, it didn't seem like you wanted to offer that for the record. I don't wish you to do that. It's not my preference. And certainly that could have been done ahead of time. But I don't think that was the witness's intention. So adding the disclaimer would satisfy my requirements. Is there anything else we need to do then, or?
Yes, Your Honor, I think that helps. And when I was looking at your comments on the offered evidence list, I think part of my second question was going to be, I wasn't sure exactly what statements you were referring to at the pages and lines that you mentioned with respect to the citation disclaimer. So there's a couple. I
believe wherever there's a citation, it needs a disclaimer. That's as simple as it gets. So if it's not being offered as an exhibit, if you don't have an exhibit citation, any other citation needs to be disclaimed.
Okay. And in that case, Your Honor, there are some hyperlinks in our testimony, which we don't intend to offer the entire document at the hyperlink as an exhibit. So we would certainly add a citation disclaimer there. With respect to the discovery responses, however, our understanding was just that the referencing the PSC reference number would be enough to have that document itself, as part of the record that the commission could rely on. If
Well,
that's not the
never been our process. PSC
Okay.
reference citation does not offer a document, so we can go through the same motion that we did with renew. But yeah, I know you shouldn't be confused about that. I know you've been involved in enough cases to know that, but
yes, and I apologize, Your Honor, for the oversight on attaching those discovery responses as exhibits. I'm happy to make a motion now, or for us to address in some other way, depending on Your Honor's preference. But to the extent we make a motion, the motion would be to submit as exhibits.
let's get on the record and have you make that request. So let's get on the record. So Attorney Vijayakar, any requests for SEIA?
Yes, thank you, Your Honor. Nikhil Vijayakar on behalf of SEIA. We would make a request at this time to file data request responses referenced in our witness White's direct testimony as exhibits to that testimony. We didn't do so at the time that the testimony was filed, and that was our oversight. So the request would be to file those data request responses as exhibits to the testimony at this time, and we could do so shortly after the hearing.
Okay, so if we were to do that, we would be marking that exhibit White 2. Any objections to that request?
No objections, Your Honor.
Okay, all right, so that'll be in. And so I'm just going to ask for the people in the room here who are participating in other rate cases currently, please adjust your filings in accordance with what you've learned here today. I think we could offer that as an errata, and I think offering the new data request exhibit as soon as you can would be helpful in those cases. So errata the testimony and the exhibit filed in those other cases, please.
Yes, Your Honor, thank you.
Okay. Any other comments? Okay, so I did want to mention that in terms of the affidavits we'll be expecting for parties, we'll want the affidavits to list the documents that are being offered for the record with the PSC reference numbers. So you'll need to file the documents first and then get the numbers and then insert them into the affidavits. So if you're refiling any documents, you want to have the updated PSC number in those affidavits. So you may need to wait till we accept those filings before you can file the affidavit. Okay, so I think that's all of our preliminaries. Got that motion, and witnesses are excused, and the offered evidence list has been reviewed. Anything else we need to handle before we call our first witness?
Your Honor, Steve Heinzen for Weeg. One question with regards to Mr. Stevens. He has simply a single correction to make on the record.
Yes.
Is it possible for Mr. Stevens to be called as one of the earliest witnesses before the substantive or cross-examination?
Yes, we'll take the non-substantive witnesses first. I think we had one other. Who else needed to clarify something? I'm not recalling now. There was someone else.
Your Honor, I believe it was witness White for
Was it?
SCA.
I think I recall that, yes. So let's call White first and then Stevens, and then we'll head on to the applicant's witnesses.
Your Honor, this is Nikhil Vijayakar on behalf of SEIA. Our witness didn't need to clarify anything. She is available, so we could verify her testimony that way. But in light of our discussion, it sounds to me like we would have to submit an affidavit anyway to reference the correct numbers. So we could just follow that process if you
That's
prefer.
fine. Let's do that. I don't always require that, but let's just make that clear. Yeah, well, it'll be better to have her, to have witness White, just file the affidavit with the document numbers listed. I appreciate that.
Certainly.
All right, so let's try witness Stevens and have Wig, we'll call it Stevens.
Yes, thank you, Your Honor. I call Mr. Stevens to the stand, please.
Okay, and I think I see you now. You're the elusive RRS. Okay.
Where,
Yeah, I'm taking care of that. Hang on.
oh, thank you.
There we go. All right, witness Stevens, raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, great. Go ahead, Attorney Heinzen.
Thank you so much. Good morning, Mr. Stevens. Could you state your name for the record, please?
Robert R. Stevens.
And did you prepare and cause to be filed direct testimony, rebuttal testimony, and surrebuttal testimony, and 3 exhibits?
Yes, I did.
Okay, and do you have any changes to your testimony or exhibits today?
Yes, I have a change to my direct testimony.
Okay, can you please point us to where that is, page and line number, and then what the change is, please?
Yes. Both are on direct Wig Stevens 2. The first change is at line 23. The 7.2% there should be 7.5%. And then for that to make more sense, I will also correct line 22. The figure of 3.8% there should be 3.75%.
Okay, thank you. Do you have any other changes?
No.
If I were to ask you today while you were under oath the questions set forth in your testimonies, would your answers remain the same?
Yes.
I have no further questions for Mr. Stevens. He is available for cross-examination.
Believe there are no cross-examination, so you're excused. Thanks very much.
Thank you, Your Honor.
And thank you, Your Honor. Appreciate it.
Yes. So please don't forget that errata in the future.
Yes.
All right. So we have Stevens. We can move on to the say you just going to verify?
Yes, Your Honor. He's here in person, but just to confirm, based off of what you said previously, the PSC reference number should be included with verified affidavits. Do you need me to include the PSC reference numbers as I introduce his testimony?
As they are now, no, that's unnecessary.
Okay, great.
Okay, so we'll take you now. So raise your right hand. Witness say, okay, do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Okay, go ahead.
Mr. Sayu, did you prepare or supervise the preparation of the written direct testimony marked as Direct Renew Sayu with attached exhibits, Exhibit Renew Sayu 1 through 4 in this proceeding on behalf of Renew Wisconsin?
Yes, I did.
In reviewing your testimony in preparation for cross-examination, did you find any errors in your testimony that require changes to those pre-marked exhibits that you would like to make at this time?
No, I did not.
Are the facts that you state in that testimony true and correct to the best of your knowledge?
Yes, they are.
Do the opinions and conclusions expressed in your testimony reflect your professional experience and best professional judgment?
Yes, they do.
No further questions. This witness is available for cross-examination.
Any questions? Thank you. You're excused.
Thank you, Your Honor.
Okay, I think we can advance to the applicant this time.
Your Honor, we would call Aaron Monroe Nye.
Okay. And I ask you to raise your right hand. So you're in the MGE witness box there. All right. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. We're having a little trouble hearing you, so need to speak up or move closer. I'm also going to highlight you for the YouTube stream, so I think I can do that Okay.
It wants me to join the audio.
I think you're fine.
Okay, I think we're good to go. So go ahead, Attorney Kleinmeyer.
Please state your name and position for the record.
Erin Monroe Nye, Energy Services and Policy Manager at Madison Gas and Electric.
Ms. Monroe Nye, did you prepare and submit 7 pages of pre-filed rebuttal testimony in this proceeding?
Yes, I did.
Is the content of your pre-filed testimony still true and accurate as of the date of today's proceeding?
Yes, it is.
Your Honor, could you please put the proposed Exhibit 1 up on the screen?
Yes, I will. I think that's it here.
Is it your understanding that yesterday Renew, through processes identified in the facilitating matters order documents, identified an intent to cross-examine you as a witness?
Yes.
And as far as you're aware, when Renew identified that intent to cross-examine you, did they provide to the parties the testimony that is contained within the proposed Exhibit 1?
Yes.
And did you review, and just for clarification, is this rebuttal testimony of Deborah E. Irwin in docket number 4220 UR 126?
Yes.
And did you review that rebuttal testimony once it was received from Renew?
Yes, I did.
And as part of your review of the Exhibit 1, did you prepare did you prepare some facts that you believed were responsive to the testimony provided in Exhibit 1?
Yes, I did.
And Your Honor, if you could put Exhibit 2 up.
Should be
if you
there.
could scroll to the second page. If you could take a minute to review the 5 paragraphs of stipulated facts, are these the facts that you prepared in response to Exhibit 1?
Yes, they are.
So, Your Honor, I'm not sure, I mean, that's kind of gives the trail of how we got to this point. And then just for your purposes, obviously, there were some discussions between legal counsel, between MGE and Renew that led to the proposed stipulated exhibits.
That's fine. I just wanted to make sure we had documents introduced from a witness, because they haven't been filed before in this case. So so that'll suffice. I just wanted to mark for the record, Monroe Nye 1 is the rebuttal testimony of Deborah E. Irwin in docket 4220 UR 126. And I'm going to give you the PSC number on this. It's 478535. I'm expecting that will not be the version we receive into the record because of filing errors. But I don't think the substance is going to change. So as far as I know, but let's just make sure we understand that this this document has not been received in the record, and it's not been verified by the author for hasn't been verified for under oath. So it's the best testimony we have right now, but it's not necessarily the final version that'll be reviewed by the commission in the NSP rate case. Also off the record, when you refile, you just want to change that witness designation on the corner there for has Pennington on that. So just so you know. And then let's get on the record again. So we also have Monroe Nye Exhibit 2. It's the stipulated facts that was just discussed by the witness. Just wanted to mark that for the record. So any objections for receiving this document, these documents in the record? No? Okay, so they're in. Just file those by Friday. And that's all we need for that process. Anything else for this witness?
No, Your Honor.
Okay. So I don't know if I asked before, but any cross-examination for this witness? Okay. Hearing none, you're excused. Thanks very much.
Thank you.
Thank you, Your Honor. We would now call Martin G. Smith.
Okay. And raise your right hand. Oh, you're in the, oh, there we go. Give you a minute there. All right. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead.
Please state your name and position for the record.
My name is Martin G. Smith, and I'm Energy Planning Manager at Madison Gas and Electric.
Mr. Smith, did you prepare and submit 6 pages of pre-filed rebuttal testimony in this proceeding?
Yes, I did.
Mr. Smith, with your pre-filed rebuttal testimony, did you also sponsor 2 exhibits in this proceeding?
Yes,
Were the 2 exhibits that you sponsored prepared by you or under your direction?
yes,
Is the content of your pre-filed rebuttal testimony and the exhibits you have sponsored still true and accurate as of today? I'm sorry, as of the date of today's proceeding?
yes,
Mr. Smith, did you review the surrebuttal testimony filed by Will Kenworthy on behalf of Vote Solar and Sierra Club in this proceeding?
yes,
And did Mr. Kenworthy state in a portion of his surrebuttal testimony that he was responding to rebuttal testimony that you had filed on behalf of MGE?
yes.
Your Honor, if you could please call up the surrebuttal testimony of Mr. Kenworthy and turn to page 13.
Okay, so off the record, should I use the new version, the errata, or does it matter?
I don't think it matters, actually.
Okay. All right. Okay, so let's pick back on the record. Let me just get that document. There.
Yeah, and so I'm just on lines 8 through 11. I was just referring to surrebuttal testimony filed by Mr. Kenworthy. He states on lines 8 through, or a portion of 8 through 11. I also note that Mr. Smith offers no proof for his claim that only utility-owned generation can be counted on and has capacity value, and that the customer-owned generation has no generation capacity value. He does not provide availability data to support his claim, nor does he point to anything in the MISO resource adequacy tariff to support that claim. Did you read that testimony, Mr. Smith?
Yes.
And do you have any responses to that testimony?
The proof that supports my position as stated in my rebuttal testimony is in the MISO tariff and Business Practice Manual 11. What I mean by that is that the whole of Module E1 of the MISO tariff and Business Practice Manual 11, or BPM 11, cover the requirements that must be met for a resource to qualify as a planning resource and receive capacity value. When planning for resource adequacy, generation resources must be qualified planning resources as detailed in Module E1 of the MISO tariff in order to receive a capacity value. As defined by the tariff, a planning resource is a capacity resource that can be used to satisfy the planning reserve margin requirement, or PRMR. Section 69A.3.1E of the MISO tariff describes the requirements for intermittent generation, dispatchable intermittent generation, or dispatchable intermittent resources, and distributed energy aggregated resources to qualify as a capacity resource by a market participant. The tariff states that resources can qualify as a capacity resource provided that the market participant A, possesses ownership or equivalent contractual rights for the resource, B, supplies historical performance data or required documentation for the resource as established in the Business Practice Manual for Resource Adequacy, BPM 11, and C, registers the resource with the transmission provider in accordance with the BPM for market registration. In addition, BPM 11 describes requirements for testing, deliverability, and performance, among others, that all planning resources must meet. Customer-owned generation does not meet these requirements and therefore is not a planning resource. If a generator does not qualify as a planning resource, it cannot be considered as providing capacity in the MISO planning resource auction. Customer-owned generation that does not meet the requirements has no direct capacity value that can be monetized in the MISO capacity market, and it cannot be treated as a planning resource. When planning for resource adequacy, such customer-owned generation does not provide any generation capacity value as a planning resource.
Your Honor, I do not have any additional questions in regard to the surrebuttal testimony provided by Mr. Kenworthy. So the witness is available for cross-examination.
Okay, any questions?
Your Honor, this is David Bender.
We're having,
I've
we
got
have
that.
to, wait, hang on, let's off the,
Yeah.
off the record. So we're gonna need you to have, yeah, clearer connection for if you're gonna be asking questions. Try putting getting closer to the phone. We'll see if that works. Let's just test it out.
Can you hear me?
That's a lot better. Yeah, if you can keep the microphone close to your mouth, that would be great.
Okay.
Okay, let's get on the record. Yeah, go ahead.
You're on a David Bender for Sierra Club and Volt Solar. I object to the testimony that just came in. It's not responsive to what it purports to be responsive to. They're kind of really pointing out what was missing from the prior round of testimony. And as I understand, what the witness just provided is supplement to provide what was missing from the prior round. That should have come in through a motion to supplement and not as rebuttal. It was also hard to follow. I mean, I understood, it seems like the witness was reading, but it seemed like he was reading part of the business practice module for MISO. And so it's hard for us to respond in real time to that kind of attempts to introduce the MISO tariff through oral testimony. So I guess as a maybe compromise, we wouldn't oppose notice of the MISO tariff itself. I think that would be appropriate as its law, but we object and would move to strike the characterizations of it by the witness in his oral testimony today.
Any response?
Well, Your Honor, I do believe that this is responsive to the rebuttal testimony that was provided by Friday, and obviously we only had a few business days to put this together. That being said, if we're able to put the tariff and the business manual into the record as exhibits, I don't think that we would oppose the striking the testimony. We obviously, and I guess so, but that we would accept that if that's workable for Sierra Club and Volt Solar.
Well, yeah, apparently that's what they're offering. Any other comments? Can I ask, how big is that document? Is it 2 documents, a tariff and a business manual? Is that?
So they're approximately, I think, each document is, let's say, between 100 and 150 pages. So large, but not exceptionally large. We could put, I mean, I guess we could work with Volt Solar and Sierra Club and Mr. Bender to try to pinpoint the sections of the tariff and the manual that address the issues and file excerpts.
Okay. Yeah, that's fine with me. I don't know if this rises to the level of impropriety or due process violation, what has just occurred in terms of the witness's testimony, but if there is an amicable way of resolving the complaint here, then we should pursue that. Yeah, we can. I mean, I don't know if exactly what the witness stated was a characterization of the tariff, or rather just kind of reciting what it says. So I think I would accept the testimony from the witness as well as the tariff. If any discrepancies or any arguments can be made against what the witness said based on the tariff, then parties can use the tariff to do that. But I didn't really hear anything slanted or spun about what the tariff says necessarily. So I'm going to deny the motion to strike, but we can certainly accept those documents either in full or redact or excerpted as the parties agree to. We can mark that document. Let's see, where will we do that? Martin Smith, back here.
I think it would be, Your Honor, if you want a single exhibit, it would be 3. If you wanted an exhibit for the tariff and exhibit for the manual, would be 3 and 4.
Well, let's just do it in one document. Just make that Martin Smith 3. We just leave it as Smith 3 since Scott Smith has no exhibits, but just label Smith 3 with either the full version of those documents or whatever parties agree to excerpt. If we have an agreement, I guess if we can try to truncate the process, perhaps just a very brief. Well, we've marked it here, so I think if you can come to an agreement, just file it. The filing will be considered the request to add the document to the record. And so the date that that's filed, I'll start counting that as the beginning of the 3 days to receive objections. If no objections are received, the exhibit will go in the record. Hopefully that'll just make things a little simpler. Any questions about that? Okay. No. Okay, so we're still with witness Smith. Any more questions?
Your Honor, this is Commissioner Hebner. I have a question.
I just wanted to make sure before you begin, Commissioner Vote-Solar, any follow-up from Martin Smith?
No follow-up.
Okay. Okay. Go ahead, Commissioner Hebner.
Yep. Could you pull that testimony back up that you were looking at, Your Honor?
Okay, so this is, sure, I get my bearings here. This is the surrebuttal of Kenworthy, Vote-Solar and Sierra Club.
Great. Mr. Smith, I wanted to just pry a little bit on your obligations within MISO. It's my understanding that you would provide some sort of a load forecast or like an obligation that you need to serve within the MISO construct, correct?
That is correct.
Yep. And so then by practice, MGE historically has provided sufficient capacity to meet that load and meet that obligation, correct?
Right. We have to meet the MISO planning reserve margin requirement, as you know, which is based on your peak load.
Okay, so that's based on your peak load. So this really gets to my question then is, to the extent that customer-owned generation is reducing that peak load, does that reduce the obligations that MGE has to provide capacity for its customers?
Right. Over time, as those resources get built and are on the system, it will impact the peak loads during the different seasons. And our forecasting would project that into the future if that indeed occurs during the MISO-defined high-risk hours. So MISO defines what peak hours they're concerned with. And so based on those hours, it will impact our peak forecast going forward over time.
Okay, great. And similarly, I'll just generally call it energy efficiency, but other actions that customers may take that would reduce load in those hours similarly could reduce or would reduce MGE's obligations to serve.
Right, assuming it is generating on the peak hours where MISO's defined that, it will affect the planning reserve margin requirement over time. And so it's treated not as a generator, but as a potential impact on your planning reserve margin requirement.
Yep. Okay, thank you.
You're welcome.
Okay, any other cross? Okay, redirect?
No, Your Honor.
All right, thanks very much. You're excused.
Your Honor, MGE would call its what I believe maybe the final witness, Brian Pennington.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name and position for the record.
Brian Pennington. I'm Director Rates at Madison Gas and Electric.
Mr. Pennington, did you prepare and submit 21 pages of direct testimony and 31 pages of rebuttal testimony in this proceeding?
I did.
Mr. Pennington, with your pre-filed testimony, are you also sponsoring 21 exhibits in this proceeding?
Yes, I am.
And have you filed an errata sheet associated with your rebuttal testimony?
I have.
And did you file revised exhibits for exhibits 13 and 17?
I did, yes.
Is the content of your testimony exhibits as amended by your errata sheet and your 2 revised exhibits still true and accurate as of the date of today's proceeding?
Yes, they are.
Your Honor, no additional questions for the witness. He is available for cross-examination.
Okay, do we have questions for the witness?
Commission has some questions, Your Honor.
Okay, go ahead.
Hi, Mr. Pennington. Just a few questions. Does the applicant have any evidence that the $400 per kilowatt in credits between the SIP 1 and 2 program, would that make rooftop solar more accessible to low-income customers?
To the best of my knowledge, it would, if there were somebody who was looking at the upfront costs for initially looking at an investment to rooftop solar, that would bring down the initial price and provide additional benefits there.
Now, to accommodate the proposed PGHE tariff, would customer meters need to be updated or modified in any way?
No, the existing meters would be ready for that service. We would utilize the same metering that we utilize today for the distributed generation solutions. We would need some time for programming our billing system. And we had planned for that, and see with the recommended timeline that commission staff had provided to extend that closure of schedule PG2 to September of 2024, that window would leave us ample time to program and accommodate the schedule PGHE.
Has the applicant considered incentivizing customers to utilize their own generation through a storage incentive tariff?
Not at this time.
No further questions, Your Honor.
Any other cross?
Yes, Your Honor. Tim Lindell for Renew Wisconsin.
Okay, go ahead.
Good morning, Mr. Pennington.
Hello, Mr. Lindell.
Should I address you as Mr. Pennington, or is there a different title that you would prefer to use?
No, I appreciate the respect. Thank you. That'll work.
Okay, great. And you have before you your direct and rebuttal testimony, as well as the 21 exhibits Mr. Kleinmeyer referenced earlier?
Yes, I do.
Okay, and then do you also have the documents that were attached to and referenced in the email sent to the service list yesterday, either in front of you or easily accessible?
I do. I have them in a loose format, so it might take me a little while to work through those, but I do.
Understood. Okay. And did you have a chance to review those documents?
Quickly, yes, I did.
Okay. All right. Thank you, Mr. Pennington. And please keep answers limited to yes or no unless otherwise specified. Okay.
Okay.
All right. So within your direct testimony, you introduce and describe MGE's proposal to close rate schedule PG2 for new customers, such that rate schedule PG1 would be the tariff under which they would take service, right?
Could you repeat that one more time, please?
Sure. Your direct testimony includes the proposal to close rate schedule PG2 such that new customers looking to take service with behind the meter distributed energy resource would need to take service under rate schedule PG1 instead, right?
Yes.
Okay. What point in the past year did MGE decide to put forward this proposal?
I don't recall the specific time. I know it would have been a discussion earlier in the year, but I don't recall the specific time.
Okay. And prior to submitting the proposal, did MGE reach out to any local solar companies in its service territory to discuss the proposal?
Not that I'm aware of.
Okay. And prior to submitting the proposal, did MGE reach out to any of the other parties in this proceeding to discuss the proposal?
Yes, we did.
Which parties?
I believe we reached out to CUB, Citizens Utility Board, Wisconsin Industrial End Users Group, Renew. I did attempt to find a contact at Sierra Club. I did not find an individual that I could connect with. I trying to recall the other parties that we reached out to, but that's what I can recall at this time.
I just want to interrupt for a second. Did you mean to say WIG, Wisconsin Industrial, Wisconsin Energy, Industrial Energy Group?
Yeah, that. Thanks for the correction. Appreciate it.
Thanks. Okay, go ahead.
All right, and thank you, Your Honor. At what point did you let Renew know your plan to revise the net metering tariff?
Your Honor, this is Brian Klein. I'm just going to object as to relevancy, as to why it's relevant, whether or not MGE reached out to parties to discuss their application.
Your Honor, the issue of collaboration has been raised both in Renew's.
I'm going to just quickly, I'm going to overrule, and but I think for background it's fine. But let's move on as far as we can. Let's try to touch this and then move on to substantive questions.
Okay, sounds good, Your Honor. Thank you. Just wondering about what time you talked with Renew about the plans to revise net metering.
To the best of my recollection, we had reached out. Part of discussions require a non-disclosure agreement for both parties, just to speak freely. And in my experience, that took a very long time. That was, if my best recollection was, that was about a 2-month period between March and April in there. And so then once we established that agreement, then we had a initial discussion prior to filing, and then we had a subsequent discussion after filing.
Okay, and how close prior to filing did that discussion take place?
I believe it was within the week prior.
Okay, thanks. And then, but you didn't reach out to Solar Energy Industries Association, Clean Wisconsin, 350 Wisconsin, or other organizations that tend to participate in commission dockets related to rooftop solar?
Objection asked and answered, and some of those parties, I would call that a mischaracterization because they have not participated in MGE dockets recently.
Just overruled on the same basis, but let's proceed.
Would you like me to answer that question then, Your Honor?
Yes.
Okay. We did reach out to Clean Wisconsin and had some discussions related to our filing. And but I don't recall making a connection with the other parties.
Okay. So prior to proposing to eliminate its net metering program, MGE did not reach out to any solar companies, but a handful of the parties that would normally participate in these types of cases. Is that right?
Objection, mischaracterization. MGE's testimony is not that it's eliminating net metering, it's that it's moving customers from one tariff to another. I appreciate that Renew may disagree with that characterization, but that's not a characterization that MGE has provided.
Okay, can you?
I can re-ask it. Yeah, I can re-ask it. Thank you, Your Honor. So prior to proposing to transition away from Schedule PG2, MGE did not reach out to any solar companies, and only a handful of the parties that would normally participate in either MGE's rate cases or dockets related to rooftop solar.
Yeah, for my direct interaction, I don't recall any other additional parties that we had reached out to.
Okay, thank you. Can we please turn to your rebuttal testimony at page 5?
Okay.
And Your Honor, would you like me to wait as I reference things for you to pull them up, or is it sufficient for the witness and I to be at that place?
Well, let's wait so the YouTube audience can also benefit from this. Usually doesn't take me this long, although
yeah,
I'm just getting a little weary here. Okay, well, no, still not enough.
And I will apologize in advance because we're probably going to be jumping around a lot here.
Okay, well, thanks for the warning. So what page do we need to be on?
Page 5, please. Lines 17 to 19.
we're there.
Okay.
Thank you. So looking at lines 17 to 19, you describe the difference between PG1 and PG2, and you state the difference between rate schedules is in the billing mechanics and how customer energy outflow is credited, specifically where schedule PG2 supports a net seller clause, right?
Correct.
Right. And schedule PG2 is MGE's current net metering tariff, right?
Yes.
Okay. And we don't need to go there, I don't think, but well, maybe we do if you disagree with this categorization, but customers under schedule PG2 receive the retail rate for all net exports until they become a net seller. Is that right?
Yes.
Okay, great. All right. Can we turn to MGE schedule PG1, please, which was served yesterday?
Off the record for a second. Sizing is not cooperating. Let's see. Okay, I think we're there. Let's get on the record.
Thank you. Are you there, Mr. Pennington?
Yes, I am.
Okay. Under the term rate on the first page of that schedule, do you agree the tariff states that the company will purchase all quantities of electric energy received from the customer's facility during each month in accordance with the parallel generation buyback rates listed in sheet E-2.2?
Yes, I agree.
And the parallel generation buybacks listed in that sheet are based on the wholesale locational marginal price of energy and the wholesale capacity auction results, correct?
I think that's a fair characterization of it. As a part of the decisions to establish avoided cost, the prices are indexed to those wholesale rates and updated to be at a fixed price for the entire subsequent year based on what values are included in fuel models for the upcoming year.
Right. They're largely a wholesale rate, though. That's a fair characterization. Is that right?
They're indexed to what is assumed for the wholesale rate in the fuel model. But otherwise, yeah, it's coming back to that. With that caveat, yeah, it ties back to be indexed to the expectations for that price.
Okay, thanks. So if MGE closes PG2 for new customers, and those customers would then be required to take service under PG1, one of the changes will be that net exports are compensated at that wholesale parallel generation rate instead of the retail rate, right?
To be compensated under the rates published in rate schedule MSC2.
And those are the
rates that you had described, yes.
Okay. So for our purposes, I'm going to just call that the wholesale rate so we don't have to say all the words every time, if that's okay with you.
Okay.
All right. All right. Can we please take a look at your exhibit MGE Pennington 11?
I apologize, is that exhibit 11?
Yes.
Okay. And would that be the net metering tariff?
Right. Yes, the second revised version of the net metering tariff. So not exhibit 2, but exhibit 11.
Okay.
All right. Are you there?
Yes, I am.
Okay, thanks. So this is MGE's current schedule PG2 with some proposed revisions, correct?
Correct.
All right. And if we go down to the heading determination of net seller status, excuse me, it says that if a customer has sold more kilowatt hours of energy to the company than they have purchased in this 12-month period, then the customer will be considered a net seller for that month. Otherwise, the customer will be considered a net purchaser, right?
Correct.
All right. And then scrolling up a bit or looking a little higher on the page under the term rate, we find that if you are a net purchaser, your net exports are compensated at the retail rate, the customer's energy rate, correct?
Yes.
And if you're a net seller, you're compensated once again at that wholesale rate, that parallel generation buyback rate, correct?
Correct.
Okay. So under Schedule PG2, the customer currently does not receive that wholesale rate unless they are a net seller, right?
Correct.
Okay. All right, and let's please take a look at what was circulated earlier. It's MGE's response to renew request for admission 7. This was in the email. No, this is PSC reference number 475023.
Off the record.
Apologies, is there a different way that I can find that?
I can show you, but I don't know if it's easy for you to get. So on our website, I go off the record on the website to IRF and then type in the reference number. Just give me that reference number one more time, please.
475023.
Oh, I'm sorry, you cut out just in the middle there.
475023.
Just to clarify, you guys are looking for the response to one renew RA7?
Yeah, that's right.
Okay, thanks.
Your Honor.
Yes.
David Bender, I don't know if it's helpful or more confusing. This is in the record as part
Actually,
of...
Attorney Bender, we're having trouble hearing you, so please repeat.
This document is already in the record as part of Kenworthy Exhibit 2.
Ah, okay, good. Thank you for mentioning that. Okay, yeah, let's refer to it by its exhibit number. I appreciate that. So we're off the record. Can you hear me?
I don't hear anything.
Oh, uh-oh.
I could hear my phone making noise, and I think it was you guys talking.
We can hear you.
Can you hear me?
Yes, we can hear you.
Okay, let me just I'm gonna go by my phone for now. Can you hear me?
Yeah, yes, we can still hear you. Okay, try, no, now, no. Oh, need to unmute. You need to press *6. Try pressing *6. Try
I
it
guess
now.
I'm unmuted now.
Oh, yeah, there we go. Yes.
Okay, I apologize. I kept hearing voices and I'm looking around who's talking and it was you guys, so sorry.
Well, I believe we were off the record, so I don't think
Sure.
any harm done there, but I'm just, so we're at Kenworthy 17, Attorney Bender, is that, I'm sorry, I missed.
I think it's 2.
Kenworthy 2.
Oh, 2, okay. So yeah, to the extent we can keep references to the record evidence, that would be useful. We can probably, yeah, and if whoever's involved in these data request responses, I would appreciate if you could keep us posted on that. So thank you, Attorney Bender, for. Wait. So this is.
I don't think
it'll be the third page.
The last of it.
Right, this is, I think there's multiple responses in here, right? So let me just make sure we have the right. So this is Kenworthy 2, and what is our
Page 3 of the PDF.
page 3 of the PDF? Okay, perfect. So
Thank you,
RA,
Your Honor.
yeah.
Thank you, Mr. Bender. Certainly my intention in calling all of these out yesterday in my email was to prep us for when we would need them, but I appreciate this approach as well.
Okay, so I think we're in the right place. Let's get on the record. Let's just have you, if you were in the middle of a question, Attorney Lindell, can you just repeat that? Let's start from the beginning.
Sure. No problem, Your Honor. I believe all I was doing was saying, can we please take a look at MGE's response to 1 Renew RA7?
Okay, and we find that in the exhibit Vote Solar Sierra Club Kenworthy 2. So go ahead.
Thank you, Your Honor. And Mr. Pennington, looking at the last paragraph of your response here. In the third sentence, you state that the net seller provision applies when the cumulative balance of Register B exceeds Register A in the prior 12 billing periods, correct?
Correct.
Right. And in that sentence, Register A is the register that records net kilowatt hours purchased from MGE, correct?
Yes.
Okay, so in order to determine if a customer is a net seller, MGE resolves the value of what the customer purchases from MGE in Register A over the course of those 12 months, and the value of what the customer exports back to MGE in Register B over the course of the 12 months. Is that right?
I'm sorry. There was a lot of static in that. And the value of what the customer, and then you kind of cut out on me.
I can just read it again.
Okay.
Or ask it again, excuse me. So in order to determine if a customer is a net seller, MGE resolves the value of what the customer purchases from MGE, which is Register A, over the course of those 12 months, and the value of what the customer exports back to MGE, Register B, over the course of those 12 months, right?
Yes.
So a customer has 12 months of purchases and credits to determine whether their exports in the current month are compensated at retail as net purchasers instead of wholesale as a net seller, right?
Yes, it's essentially a rolling annual reconciliation. So once we see 12 months of being a net seller, then they are defined as a net seller by the provisions of the tariff.
And that calculation won't take place under PG1, right?
That's correct.
Because there is no net seller provision in PG1, right?
That's correct.
Okay. So under PG1, a customer is paid at the wholesale rate as soon as they export, regardless of what happened in the prior 12 months, correct?
Yes, under the definition we talked about before, where they schedule MSC2 rates are the whole, if we're saying those are the wholesale rates, it's essentially the exact same rate level applied, but just it's applied in that month under PG1, as opposed to waiting for the net seller reconciliation.
Okay. And in terms of energy that's generated from a PV system, some of the kilowatt hours that are generated go to offset load that's being generated at the home, and the rest are exported across the point of common coupling, right?
Yes.
I'm sorry, across the.
Point of common coupling.
Thank you.
So comparing PG1 and PG2, under PG1, no net exports are valued at the retail rate, right?
Yes, that's correct.
And so more kilowatt hours from a solar system are valued at the wholesale rate under PG1 than under PG2, because all exports are valued at wholesale, right?
Yes, that's correct.
Okay, thank you. All right. In your rebuttal, Mr. Pennington, you proposed a new tariff, Schedule PGHE, which you attached as Exhibit MGE Pennington 10, correct?
Yes, that's correct.
Let's go off the
All
record
right.
for a minute. Here we go. All right, back on.
When did MGE decide to propose Schedule PGHE?
It was responsive to the direct testimony we had received, and kind of in light, I think I outlined that in my rebuttal testimony, kind of what factors we took into consideration.
So it was put together between parties, interveners direct and MGE's rebuttal, right?
Yes, that's when we had put it together, yes.
Okay. And apologies, Your Honor, in your rebuttal testimony on page 4, lines 3 to 7. Let me know when you're ready, Mr. Pennington.
I'm at that point. Thanks for checking.
Okay, sure. You are asked whether you are aware of similar tariff proposals from other Wisconsin utilities, correct?
Yes.
And you point to Wisconsin Power and Light's proposal in its rate case, right?
Yes.
And one of those similarities is, I think, what you describe as an hourly inflow-outflow structure, correct?
Yes.
Are there any other similarities between the two proposals?
I did, in the context of the tariff, I did edit the availability clause to 20 kW for alignment. That was one of the additional adjustments that I made to it.
Okay. And MGE is proposing an outflow transition adder of 5 cents per kilowatt hour, as well as part of proposed tariff PGHE, right?
The 5 cents per kilowatt hour served as an example of what the commission could consider, or what would be effectively an incentive for how we could go about a transition. Really, we're looking at our tariff as being an iterative step, acknowledging the commission's decision on avoided cost, and then recognizing that there is an impact going from one tariff to the next. As I said I believe it was on page 30 of my rebuttal, we're not opposed to considering incentives. It's just this framework allows it to be more transparent.
So but it is not intended to be similar to the system asset value credit that WPL is proposing.
I apologize, you've maybe gone a layer deep than my familiarity with the WPL proposal.
Okay, so you're not familiar with the system asset value credit that is being proposed in WPL's proceeding?
No.
Okay, thanks. And I think you just touched on this, but just want to make sure I have it right. In discovery, when asked to explain the company's rationale for setting the adder at 5 cents, you responded that this is just an example value.
Correct.
Okay. So MGE did not set the outflow transition adder at the embedded capital cost for its marginal generator or something like that.
No.
Okay. And MGE has not provided a methodology for how to calculate the outflow transition adder, since it's just an example, right?
That's correct.
Okay. And the outflow transition adder is not currently included in any of the tariffs MGE has proposed to date, including tariff PGHE.
That's correct. From my testimony, I had suggested that the outflow transition adder could replace the supplemental incentive, the SIP provision. So it could actually be on that tariff instead.
And MGE has not described how long the outflow transition adder will be available to new customers taking service under PGHE, right?
We really, consistent with the testimony, we really wanted that to be something that the commission could control. So I know we did not set a expiration or set an expectation that it was going to go down or up or remain flat. That would be what we're suggesting is if in that incentive structure, it'd just be very transparent for the commission to manage.
Okay, and MGE has not stated whether the amount of the outflow transition adder can change over the lifetime of a customer's system, right?
Correct.
Okay. Thank you. Okay. All right. Let's turn to your direct, please, at page 12, lines 8 to 9.
Off the record.
We are close to done with jumping around, Your Honor.
That's fine. That's what I'm here for. It's the Wisconsin way, jumping around. So, what page are we?
Page 12, please.
Okay, I'm there.
Okay, thank you. Are we on? I'm sorry, Your Honor.
Oh, I don't know. Oh, yeah, let's get on the record. All right, thanks.
Thanks. Okay, so looking at lines 8 to 9 here, you describe the SIP, the solar incentive provision, and state it will be capped at 5 kilowatts, right?
Correct.
And you also describe how the incentive will be limited to the first 400 MGE customers that sign up for it, right?
Yes.
Okay. So do you agree that customers will have an incentive, for example, to install a 5 kilowatt system instead of a 6 kilowatt system in order to remain eligible for the SIP?
No, I don't think eligibility, like if you have a array larger than the 5 kW, you continue to be eligible for it. It's just the credit would be available up to that 5 kW limitation.
Okay, but they would incur costs to install any kilowatt beyond that 5 kilowatts, but not receive an incentive for that, right?
Maybe I'll say it a different way. That 6 kilowatt of capacity on the solar array would not qualify for an additional $200 credit.
Right. So that marginal kilowatt, if you will be more expensive for the customer than the first 5 kilowatts.
Absent any other changes, yes.
Okay, and that increase in price might incentivize a customer to install a smaller system, right?
I'm to object as to speculation.
It's a hypothetical.
Okay, so understanding it's a hypothetical, you can answer.
It's hard to speculate. I don't know. I mean, the way we assessed the fit of a solar array, we looked at hundreds of our customers that in real experience, it really varies in how they're matching their size of their system to their load. So I can appreciate some aspect of what you're saying that, by offering a credit and it stops at some point or has a point at which it's not available beyond a certain capacity level, it doesn't further incent larger and larger systems. The intent is not to do anything but provide support in the front end, rather, quite frankly, I'm not looking at it as a negative to end at some point. It's more of a positive that you provide it up front to begin with, if that makes sense.
Yeah, okay. Thank you. And with regard to the 400 customer suggestion, the 401st customer does not receive an incentive, right?
I'm sorry, could you repeat the question?
The 401st.
Oh, let's read it back. Read back the question.
I'm sorry. With regard to the 400 customer system, the 400 customer is not to receive any incentive, right?
Within that year, correct. So if to the degree that historically everything that I've seen on this record, it appears everybody's amenable that our growth rate is between 350 and 400 customers per year. To the degree we're getting towards the end of the year and the customers, one of those last 401st installers, then they would make the decision to energize and not receive the credit, or to essentially be on the waiting list for the subsequent year.
Okay. Thank you. Let's come at this from a different way. So let's take schedule PG2, the existing net metering schedule. Would you agree that a customer that installs a 6 kilowatt system will end up purchasing less electricity from MGE than a customer that installs a 4 kilowatt system, all other things equal?
Boy, I usually think of a customer as sizing their system for their load. So I mean, if you're saying there's a sizable difference in the total kilowatt hours that are produced between those two sizes of system. And so we would expect that a customer is matching their output to their load. So it's kind of hard for me to, I'm not trying to, I apologize. I'm not trying to be, I want to answer your question, but maybe there's a different way you can ask it to me.
Yeah, let me give you another. Let's add a fact to the hypothetical. So let's just say a customer, the customer's load would, if it was perfectly matched to the amount of the generation, would result in an 8 kilowatt system. So in that scenario, if that customer installs a 6 kilowatt system, they will purchase less electricity from MGE than if they install a 4 kilowatt system, right?
Correct, yes.
Okay. And so the amount of revenue MGE would earn from that customer would decrease between 6 kW and 4 kW.
I'm not sure I follow that calculation.
Well, if the customer purchases less electricity from MGE receives less revenue from that customer, right?
Oh, sure, yes.
Okay. And if two neighbors both have a 5 kilowatt solar system, they will collectively purchase less electricity from MGE than if only one of them has a 5 kilowatt system, right?
Yes.
Okay. And if these customers purchase fewer kilowatt hours from MGE on account of investing in solar, MGE will see less revenues from those two customers than they otherwise would, right?
Mr. Lindell, I'm sorry, I didn't hear the question. Can you repeat it?
No problem. Happy to ask. Sure. If these customers purchase fewer kilowatt hours from MGE on account of investing in solar, then MGE will see less revenues from those two customers, right?
Yes, that's correct.
Okay, thank you. All right, can we please turn to Exhibit Renew Vickerman 2?
Okay, off the record. I think we're here. Let's get back on the record.
All right, Mr. Pennington, Exhibit Renew Vickerman 2 is MGE's Form 10K submitted to the Security and Exchange Commission on December 31st, 2022, correct?
Yes.
And you've had a chance to review this exhibit?
Yes, I have.
Okay, thank you. If we look at the bottom of page 20, so the page 20 of labeled within the exhibit, as opposed to the 20th page because there are only 6 pages.
I think we're there.
All right. Mr. Pennington, do you agree that at the bottom of page 20, there's a heading that states operating risk?
Yes, correct.
Okay, and then going on to the next page, the second heading under that section, so the first subheading on this page, Your Honor. Would you agree, Mr. Pennington, that that states that we, being MGE, could be adversely affected by changes in the development and utilization by our customers of power generation, storage, and use technologies?
I agree. That's what it states here, correct?
And you agree that the next sentence states, our revenues and the timing of the recovery of our costs could be adversely affected by improvements in power generation, storage, and use technology?
Yes, I agree. That's what it states there. Yep.
And that sentence in this section is identifying a revenue risk for MGE shareholders, right?
That's generally the purpose of the 10K. You know, just kind of covering all of the potential, the wide array of risks that can happen to communicate to a share owner. Yes.
Okay. And going down to the last paragraph in this subsection, the first sentence there states changes in power generation, storage, and use technologies could have significant effects on customer behaviors and their energy consumption. And then skipping a sentence, or I'm sorry, is that right?
Yes, that's what it states there.
Thanks. And then the third sentence states they, and I think they as customers here, could also change their consumption of electricity through the installation of alternative energy sources such as rooftop solar panels. Is that right?
Correct. That's what it states.
And it goes on to state that customer energy conservation measures, such as those, quote, could adversely affect our results of operations by reducing our revenues without necessarily changing our operating costs due to our obligation to serve, right?
Yes.
Okay. All right. Mr. Pennington, would you agree that this document shows that MGE has a motivation to limit revenue risk on account of distributed energy resources for its shareholders?
I think that's a fair characterization of concerns. I think we want to, from an MGE perspective and our share owners, it's always appropriate to have costs and revenues aligned. Having that aligned, there's, as I testified to it, there's no distributed resources are perfectly aligned then with that perspective. It's just ensuring that we have that alignment between revenue and cost.
Okay, thank you. Lastly, Mr. Pennington, can we turn to your rebuttal, please?
Yes.
Off the record. Oh, I got it right here. Go ahead.
We're back on, Your Honor?
Yes.
Okay, thank you. Page 8, please. All right, looking at lines 8 to 12 here, you reference a report from the State Government Leadership Foundation and then attach that report as exhibit MGE Pennington 6, right?
Yes, I did.
It's 16.
Okay. 16. But before we go to that exhibit, please, Your Honor, Mr. Pennington, on line 10 here, you're citing the report as stating that net metering policies are deeply regressive, right?
Yes.
Did you say aggressive?
Regressive.
Aggressive? Regressive, thank you.
Regressive. Some might think they're aggressive too. All right. And Mr. Pennington, that report was written for the State Government Leadership Foundation, right?
Yes, it was published by them.
Okay. Do you agree that the State Government Leadership Foundation's purpose is to develop and support conservative policies?
Yes.
Okay. Do you agree that the State Government Leadership Foundation is in favor of policies that support limited government, low taxes, less regulation, and individual liberty?
That may be their mission statement or something to that effect.
Okay. Do you agree that the State Government Leadership Foundation is a strategic partner of the Republican State Leadership Committee?
That's a layer deep than my understanding of the group.
All right. Your Honor, can we please turn to the document that was circulated via email entitled State Government Leadership Foundation homepage?
I'm way ahead of you. I think that's it.
Okay, thank you, Your Honor. Can you please go to the second PDF page of that exhibit?
So off the record, I just wanted to remind everyone, if we're going to introduce this as an exhibit, we'll need to mark it and offer it. So right now we can discuss it on cross, but it won't be in the record unless it's offered as an exhibit. So, okay, let's get back on the record.
All right, Mr. Pennington, excuse me, Your Honor, would you mind going to the next page, please?
Oh, sure. Yes.
Looking at the second paragraph here, Mr. Pennington, do you agree that the last sentence states, "We help to plant seeds that flourish into freedom, opportunity, and prosperity rooted in limited government, low taxes, less regulation, and individual liberty"?
Yes, that's what it states.
And in that next sentence there, it states that the State Government Leadership Foundation is a strategic partner of the Republican State Leadership Committee, right?
Correct, yep.
And it also states that SGLF is a 501c4 social welfare organization, right?
Yes.
So is it safe to summarize that this report was prepared or published by a right-wing lobbying group?
Just a question, when you say report, are you referring to what you're talking about right now or Exhibit 16 for Pennington?
Thanks for the clarification. I can re-ask the question. Mr. Pennington, would you agree that your Exhibit 16 is a report prepared for a right-wing lobbying group?
It was prepared for the State Government Leadership Foundation. I'm not trying to be evasive on it, but I just to kind of characterize it that way, I just see it as being an organization provided a report.
And their purpose is to promote Republican ideas, correct?
Yes.
And between the two terms left and right, a Republican is normally considered to be on the right.
No, that's fair.
Okay. All right, can we please bring up Exhibit 16, please?
Okay, off the record. Dig through my windows here. Add it again.
And then we'll go to the very last page, please.
Okay, yeah, thanks.
Thank you, Your Honor. It's actually the second to last page. My apologies.
All right, let's get on the record.
Where I was going. All right, Mr. Pennington, looking at the last page of Exhibit MGE Pennington 16, do you agree that this section is an about the author section?
That's the second to last page.
Yes.
Okay. That is yeah, it's a biography for the author.
And the author is identified as Tom Tanton, right?
Yes.
Okay, and looking at the second to last sentence in the about the author description, it states from 2003 through 2007, Tanton was senior fellow and vice president of the Houston-based Institute for Energy Research, right?
Yes.
Okay. Do you agree that while at the Institute for Energy Research, Mr. Tanton authored a report published for the American Legislative Exchange Council, or ALEC, in 2005 entitled Motor Fuel and Natural Disasters Don't Regulate?
I was never familiar with this report until you shared it yesterday as an exhibit or a supplemental exhibit.
But you agree that he's listed as the author of that report?
Yes.
Okay, thank you. And going back to this about the author, looking at the last sentence here, it states he was also a senior fellow in energy studies with the Pacific Research Institute until 2010.
Yes.
Okay, and do you agree that while with the Pacific Research Institute, Mr. Tanton authored a report entitled Top 10 Energy Myths?
Again, I wasn't aware of the report, but I did see that you shared that report yesterday as a part of supplemental exhibit.
Okay, thank you. Your Honor, would you mind bringing up that report? It was one of the documents attached to the email.
Top 10 energy myths?
Yes, please. And scrolling down, please, to the PDF page 4, which would be the third page of the article itself. The next page, please. Oh, sorry if I'm confusing you. It's the one with the attribution page, if you will. It's the third page. This one right here. Thank you. Mr. Pennington, do you agree? I'm sorry, Your Honor, are we on the record?
Oh, let's get on. Yeah.
Okay. Mr. Pennington, would you agree that this page of this document states top 10 energy myths by Tom Tanton, November 2009, Pacific Research Institute?
Yes, that's correct.
Okay. And do you agree that this article argues, among other things, that increased motor vehicle efficiency has not lived up to its promises, that the U.S. should expand offshore oil drilling, and that renewable energy will remain a very small fraction of our energy mix for the foreseeable future?
Yeah, I scanned it briefly, but that's probably a summary of this particular report that's put together in 2009. Yeah.
Okay, thank you. So do you agree, Mr. Pennington, that your Exhibit 16, on which Madison Gas and Electric is relying in this case, was written by a pro-oil and gas author for a right-wing lobbying group?
In the context of how you explained a right-wing lobbying group before, it was written by this Tom Tanton, yes.
Okay. Your Honor, I don't have any further questions. Thank you.
Okay. Any other cross?
Your Honor, the city of Middleton has some cross. We'll be short.
Go ahead.
Mr. Pennington, are you familiar with MGE's publicly stated decarbonization goals?
Yes.
And am I correct if I state that those goals include 80% decarbonization by 2030 and net zero carbon by 2050?
Yes.
And those goals have been publicly shared with shareholders. Is that correct?
Yes, they have been.
Customers are aware of those goals as far as you know?
As far as I know, yes.
And investors would be aware of those goals as well, I take it.
Yes.
And in fact, those goals have been contained in a a corporate responsibility and sustainability report that is widely available to the public.
Yes, to the best of my knowledge, yes.
And you're familiar with that report being generated by MGE?
Yes.
You've been asked a lot of questions about assumptions made in coming up with the various proposals relating to net metering changes and the underlying assumptions there. Can you tell me if you've done any analysis of how MGE's net metering proposals in this case address MGE's stated decarbonization goals?
You know, from our evaluation of it and what we're proposing, we haven't seen a meaningful impact to the buyback or the payback, the break-even time periods. You know, when we ultimately look at managing that with right size generation and the installations we've seen that reflect the installations that we've seen to date, the hundreds that we've seen to date, that we think the payback still remains in that 9 to 12 year window for a large portion of our installations. And so our proposal manages the cost for non-participants and keeps the cost lower, but we don't think it impacts the overall investment path that customers will still continue to choose to do customer-owned generation.
Have you done any analysis of how much rooftop solar would have to be installed in MGE's service territory to achieve its decarbonization goals?
I have not, no. I know that we've been on pace for, in the context of our historical installations, we've seen in between 350 to 400 installations in the recent years. So,
but you haven't done any analysis of where rooftop solar fits in with MGE achieving its decarbonization goals?
That role would fall in more with a resource planning role. And so it's not something I would directly be involved in.
Do you think it's not important that in designing a net metering proposal that you shouldn't look at what are those long-term decarbonization goals?
I'm going to object the statements. Do you not think it's important as a mischaracterization of the testimony that the witness has provided?
I'm just asking.
And it's argumentative.
Overruled.
I'm not sure how to answer the question other than we aren't anticipating that we are disrupting the installation patterns. I think that, you know, I wouldn't have the expertise to really see how that fits into the resource planning for myself specifically. But I don't, you know, in terms of like how we're changing our policy, we just generally don't see the depending on where we would go with the balance of incentives, we don't really see that significant disruption of the payback period for the right size generation.
I'm assuming, well, let me ask you this. Do you agree that rooftop solar has an important role in MGE achieving its decarbonization goals?
You know, if it's size behind the meter, as long as you're using it, nothing's changed in our policy. The only thing that's changed in the policy is the compensation for excess generation that we're purchasing, which would reduce costs for non-participants. So I think we look at it as being very important to be partnered with the customers and see it definitely not an intent to move away from that resource at all. It's just striking a balance for solar owners and for non-participants.
So you've offered your opinion here today, which I appreciate, but have you done is there any analysis that has been done to put this net metering proposal in the context of how MGE achieves its decarbonization goals?
I think in the context of installing the installation patterns we've seen where there's 3.5 megawatts that have been roughly installed annually, and in the context of having roughly 20 megawatts life to date for all installations, and having approximately 2,000 customers that have rooftop solar now, and in the context of it growing, like I said, between 350 and 400 customers a year, relating that back to having roughly 166,000 customers, it's a small but important part of the equation. You know, if we keep our trajectory on that, it seems to be aligned with our overall portfolio. But it's a smaller portion.
Okay, so then I think we agree that rooftop solar is a key ingredient in MGE reaching its decarbonization goals.
I guess in the context of it being a portion of it, it's there. You know, everything's important. You know, in terms of decarbonization goals, I would never walk away and flatly dismiss it. One of the issues we have really with this service is you're purchasing non-renewable energy. So the customers achieving their personal carbon reduction goals, but the relationship for the utility here is buying non-renewable energy. And so when we're buying that incremental non-renewable energy, it doesn't help non-participating customers to achieve the system carbon goals. It's really, we're providing an outlet for a customer to sell the energy to us, and then they retain the renewable attributes for their personal goals.
When you say that you're not purchasing or you're purchasing non-renewable energy, you're referring to the fact that MGE is not purchasing the renewable energy credits?
Yeah, all of the renewable attributes stay with the solar owner.
But the solar energy itself that is sold to MGE, that is a renewable energy source, is it not?
I would disagree. Once you've removed the attributes, it's from a transactional perspective, it's just an energy transaction that doesn't have a renewable tag associated with it.
Well, from a physical engineering standpoint, a solar installation produces solar energy, doesn't it?
A solar array produces energy, yes.
It produces renewable energy, correct?
A solar array produces renewable energy, yes.
Yeah. Well, thank you for that. No further questions.
Okay, other cross? Nobody? All right, redirect.
Yeah, just a few questions, Your Honor. And if you could pull up rebuttal MGE Pennington 8, which was the page that Mr. Pennington was asking cross-examination questions on.
Sure, just a minute. There, okay, go ahead.
Focusing again on lines 8 through 14, Mr. Pennington, what was the purpose for you sponsoring and filing exhibit MGE Pennington 16?
So, you know, in direct testimony that we received from interveners, there was a lot of evidence suggesting that there's a disconnect where higher incomes were benefiting from net energy metering policies as opposed to lower income customers, that there's a gap at participation there. And then just foundationally, the cost of an array requires disposable income or a good credit score, and frankly, a roof. You know, you have to pragmatically have that. And in and of itself, that cocktail of not having that for a lower income customer would suggest that it's a regressive policy unless we can somehow address that in some ways. Aligning essentially some of the comments that we had seen from the Dane County witness in the evidence that we had on that. It was interesting to see with another lens, another side of the equation. A lot of it was saying the same thing, that there are these concerns about it being a regressive policy. And so that was the intent of introducing that exhibit.
Thank you, Your Honor, for bringing that up. Changing course, in utility rate cases, is a factor the commission considers when approving rates the forecasted sales volume.
I'm sorry, could you repeat the question?
In utility rate cases, is a factor the commission considers when approving rates the forecasted sales volume.
Yes.
And can the forecasted sales volume change from rate case to rate case?
Yes, it can.
You were asked a number of questions regarding MGE's decarbonization goal. Are you aware of utility scale or solar projects that the MGE is involved with over the last number of years?
Yes.
Is one of those Badger Hollow and Badger Hollow 2?
Yes.
Is another Paris Solar Farms?
Yes, that's another project.
Are there any other projects that you can identify?
You have the O'Brien Solar Field, Maury Solar Field, a lot of the there's a lot of the RER agreements we have in collaborating with customers and our shared solar projects. There's a lot of solar at this time.
No further questions, Your Honor.
Okay, just off the record. So you mentioned RER projects?
Oh, yes, I apologize. It's the renewable energy rider.
Okay, just wanted to check for the record. That's fine.
Yep.
Okay, looks like we had a hand up here. Let's get on the record. There are some follow-up questions.
Your Honor.
Yes, Your Honor,
Commissioner
just
Hebner.
one.
Oh,
And
sorry.
I had some questions. Okay, just one sec.
Oh, Commissioner. Okay, go ahead.
I didn't get off mute earlier quick enough. I'll let the other speaker go ahead with his question, but I had another line of questionings for the witness.
Okay, sure, no problem. So Attorney Lindell, were you up next?
Yes, but I'm nervous to take the commissioner's spot. But just one quick question. Going back to the questions. Going back to the questions that Mr. Kleinmeyer asked you about your Exhibit 16. Mr. Pennington, if solar is less affordable for customers, who will be able to afford solar? Those with more money or those with less money?
I would assume that those with more money are going to be able, absent any other changes, those with more money will have more access to solar than somebody with less money. It's all about disposable income at some level.
No further questions, Your Honor.
Okay, so Commissioner Hebner, do you have questions?
Yeah, I do. Mr. Pennington, you mentioned your latest proposal would reduce the maximum size of solar that's eligible down to 20 kilowatts.
That's how we introduced the tariff. I should have added more context to it, that really the hope was that we would have, in the context of all the decisions, that we'd have some parity or off. We know there's a very strong dialogue about having consistency in the state. And so it was really an offer to say, if decisions are made, that we see some consistency with that parameter.
Okay. Did you provide for the record how many customers fall within that range under PG2 today that would be 20 kilowatts to 100 kilowatts?
My best recollection is that 95% of the arrays fall within the 20 kW or less.
Okay.
I recall that there were roughly 125 arrays. I know there's a discovery request that asked this, but I think it's roughly 125 arrays that are greater than that.
Okay. So for a customer that would be in that 20 kilowatts and above, they would not be eligible for your revised tariff. So if PG2 is eliminated, they would default to PG1 under your proposal.
They'd actually be they'd be grandfathered for under the existing tariff. So it'd be closed, but it'd still continue to be available for them.
Okay. So existing customers would be grandfathered, but any new customer at the point which these tariffs would take effect, after that point, any new customer wanting to do, say, 21 kilowatts of solar would be under PG1.
Correct. That'll be an important consideration when thinking about those limitations for any of the tariffs. Correct.
Great. The other, I think I'll leave it there. Thank you.
All right. So any redirect?
No, Your Honor.
No. Okay, this is it then. Thanks very much. You're excused. And is that the balance of the MGE witnesses?
That is, Your Honor.
Okay. So if my recollection serves me correct, we just need to verify commission staff witnesses, or do we have someone else to take?
Your Honor, real quickly before we move on, is now a good time to move to admit exhibits used during cross, or would you like me to wait until later?
Oh, let's do that. Sure, we can offer that. What do we have? Just kind of close some of those up. Okay. Yes, we can. We can. So we have. Okay, so which ones do you want to offer? Because I don't think you went through all.
They
of
were
them.
Your Honor, I would, it would be the attachments to the email. Everything else that is listed with reference numbers is something that we will address. That was already included in our witness's testimony. We need to put together the exhibit and we'll get it in that way. But it's the new documents attached to the email that I'll seek to move.
Yeah, and that's, I guess, I don't think we. Okay, let's go off the record. So let me just bring them all up.
There should be 5.
And okay, and then the additional homepage. So we don't need to review the Irwin testimony. That was also in the email.
You're right. Yeah.
Okay, so we have sizes. Okay. So this would be a Pennington exhibits. I don't know if how big these documents are. If we can mark them as one Pennington exhibit, that might be useful. So yeah, go ahead.
We might need to. We might need to. The homepage document, for some reason, when I turned it into a PDF, was gigantic, and I couldn't. It's like 12 megabytes, and I couldn't move it with everything else. I couldn't email it with everything else, so we might need to.
Okay. Yeah.
I think it's just because it's the picture or something.
Okay. Okay. Let's start with this then. So we have this. So let's get on the record. So we have few documents here that were used on cross of witness Pennington. Renew Wisconsin is looking to mark them, and then we will ask for objections to that offer of these documents as exhibits. So the first one, because of its size, we'll mark as Pennington. Whoops, let me check one more time. Pennington 22, the State Government Leadership Foundation homepage. And then the remainder of the documents, remainder of the documents may be able to combine into one exhibit, which would be Pennington 23, the ALEC report. So are we looking at schedule PG1 was also discussed? I don't remember that being discussed on cross.
Yes, it was, Your Honor.
Okay, and and then sheet 2.2. I think it was mentioned, but we didn't have it. We didn't have the witness actually review it, did we?
I believe he did review it, Your Honor.
Okay, all right. And then top 10 myths, I believe we did go through that. Okay, all right. So exhibit 23 will be the ALEC report, the MGE schedule PG1, the buyback rate sheet E2.2, and the top 10 energy myths article. Okay. So, okay, so let's get on the record.
We were on the record.
We were on. Okay, good. I have to do it again. Perfect. So any objections to those documents going in the record as we detailed?
No objection. I always find it interesting that records have to go in under our name when we didn't provide them, but I understand that's the process.
Well,
I
it happens with everyone.
Yeah.
All right. Okay, so we'll expect those filings in by Friday. So we're done with Pennington. It's almost 1 o'clock. Let's get off the record. So it's just the remaining commission staff to verify documents. Is that correct?
I believe so, Your Honor.
And let's just review any questions for these witnesses that we know of. No, so I think we'll try to take care of these now, and then we'll be done. So I don't think there'll be too much problem. Yes, go ahead. 5-minute break. Okay. Yeah, let's take 10. Oh, let's get back at 1:10.
Thank you.
Okay.
Sorry.
Thanks. Yeah, don't disconnect. Oh, no. Just you can turn off video. Yeah, there you go. Turn off video and mic's good.
Hello?
Mr. Kleinmeyer, can you hear me?
I can hear you, yes.
There we go. Okay. This is a nightmare. Not PSC, but something's going on with my computer.
So there's only 3 of us on right now. This is a lot shorter than the zoning board of appeals meeting that Krista and I had participated in Wanakee a few years back.
That is the truth. And I appreciate that this one is during the day also.
Yeah.
If y'all want to see my face for 5 more hours, you can come to the Village of Shorewood Hills Board of Trustees meeting tonight. We should be there until about midnight.
What's happening there?
It's just a regular board meeting, but just got a lot of little things going on.
Are you on the board?
I am.
Oh.
I actually filled a 1-year vacancy. And I think I'm probably done. As committed as I am to public service.
Usually they get you with that 1-year appointment and then you never leave, right?
Yeah. I'll have to check in with my family in a few months.
All right. Well, I think we're about ready to go. Oh, got another second here. There we go. All right, let's get on the record. It's 10 after 1. So we're here to take the rest of the witnesses. I think just commission staff needs to verify their testimony. So have Attorney Peters call the first witness.
Thank you, Your Honor. The commission would call Chastity Clark to the stand.
Okay, I'm going to ask you to raise your right hand. Here you go. Do you swear? Oh, I'm going to unmute your microphone. Perfect. Okay. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. Oh, you got a problem? Okay. Wait.
Ask if you could move your camera so I can see your face because your face is cut. Thank you.
Okay, thanks. Okay, go ahead, Zach.
Please state your name for the record.
Chastity Clark.
What is your position at the Public Service Commission of Wisconsin?
I am a program and policy analyst.
And how are you involved in this docket?
I gave testimony.
And are the statements and representations in that testimony that you filed in this case true and correct?
Yes.
Did you have any additions or modifications to your testimony at this time?
Not at this time.
Your Honor, the witness is available for cross-examination.
All right, any questions? Okay, I'm not hearing any, so thanks very much. You're excused.
Your Honor, the commission would now call Andrew Eider to the stand.
Okay, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Please state your name for the record.
Andrew Eider.
And what is your position at the Public Service Commission of Wisconsin?
I'm a public utility rate analyst.
And how are you involved in this docket?
I presented direct, supplemental direct, rebuttal, and surrebuttal testimony.
And are the statements and representations in that testimony that you filed in this case true and correct?
Yes.
Did you also file or cause to be filed exhibits marked PSC Eider 1R, 2R, 3, 4, and 5R in this case?
Yes, I did.
And are the statements and representations in the exhibits you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No.
Your Honor, the witness is available for cross-examination.
Hey, any questions? Okay, hearing none, you're excused. Thanks.
Thank you.
Your Honor, the commission would call Eric Griffin to the stand.
All right. So I'm gonna put a twist in here. Is there a possibility to turn that background off? Depending on what's behind you.
Me?
No, Eric, there you go.
Oh,
Yeah,
okay.
thanks. It's a little distracting for me. So, okay, let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
And please state your name for the record.
Eric Griffin.
What is your position at the Public Service Commission of Wisconsin?
I'm a public utility auditor.
And how are you involved in this docket?
I was the case coordinator and presented direct testimony, rebuttal testimony, and surrebuttal testimony.
And did you file, or are the statements and representations in your direct rebuttal and surrebuttal testimony filed in this case true and correct?
Yes.
And did you also file or cause to be filed exhibits marked Exhibit PSC Griffin 1R?
Yes.
And do you intend to file any delayed exhibits in this docket?
Yes, I plan to submit the public comments exhibit.
Were you also involved in the preparation of Exhibit PSC Staff Data Request Response Exhibit?
Yes, I was.
And is that exhibit, are there further updates planned for that exhibit?
Yes, there was an additional question and response that came in this week that I will be updating for.
And are the statements and representations in the exhibits you filed in this case and will cause to be filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
Hey, any questions for the witness? Not hearing any, so thanks very much. You're excused.
Your Honor, the commission would call Mitchell Horry to the stand.
There you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? I'm not able to hear you. You're not muted, so I'm not sure. Just go off the record for a minute.
Can you hear me?
Yes. Nice and loud. Okay, great. Okay, so let's start over here. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so back on the record. Go ahead, Attorney Peters.
Please state your name for the record.
Mitchell Horry.
What is your position at the Public Service Commission of Wisconsin?
My position is the Focus on Energy Performance Manager.
And how are you involved in this docket?
I filed direct testimony.
And are the statements and representations in the testimony you filed in this case true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I don't.
Your Honor, the witness is available for cross-examination.
Any questions? Seeing none, you're excused. Thanks very much.
Your Honor, the commission would call Michael Ritsema to the stand.
See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Please state your name for the record.
Michael A. Ritsema.
Now, what is your position at the Public Service Commission of Wisconsin?
I'm a public utility auditor principal.
And how are you involved in this docket?
I filed direct and rebuttal testimony.
And are the statements and representations in the testimony you filed in this case true and correct?
Yes.
Did you also file or cause to be filed an exhibit marked EXPSC Ritsema 1?
Yes.
And are the statements and representations in the exhibit you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
I would add that I will be providing a delayed exhibit for the market price update.
Okay, we're going to mark that Ritzma 2.
Yep. Okay.
Thanks. Any questions for the witness? No, seeing none, you're excused. Thanks.
Thank you.
Finally, Your Honor, the commission would call Reed Tierney to the stand.
See you there. Can you turn your camera on?
Sorry, I'm trying to get my camera to work here.
Okay.
Was working earlier.
Go off the record for that. No, not having any luck.
Yeah.
Well, we can proceed. We can hear you well. So
Okay, yeah. Sorry, I'm not sure why it's not coming on here.
that's okay. It happens sometimes. So so let me swear you in. Raise your right hand. Let's get on the record. And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead, Attorney Peters.
Please state your name for the record.
Reed Tierney.
What is your position at the Public Service Commission of Wisconsin?
Public utility financial analyst.
How are you involved in this docket?
I submitted direct testimony.
And are the statements and representations in that testimony filed in this case true and correct?
Yes.
And did you also file or cause to be filed an exhibit marked EXPSC Tierney 1?
Yes.
And are the statements and representations in that exhibit true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibit at this time?
Not at this time, no.
Your Honor, the witness is available for cross-examination.
Hey, any questions? Nothing? All right. Thanks very much. You're excused.
Nothing further, Your Honor.
Okay. Well, it's all of our witnesses, so I'm not sure if we have any other outstanding matters to discuss.
Your Honor, Krista Westerberg here for BPSA.
Sure.
The Sierra Club and BPSA had filed a request for ALJ order back in August about the facilitating matters order, and I don't know that it's really that relevant for this proceeding any longer since the public comment period is nearly over, but just as guidance for future cases, was wondering if you had planned any other changes to the facilitating matters order in response to that, since it's common across cases.
No, I'm not going to respond to that motion, and I think the facilitating matters order speaks for itself, so just use that as your best guide.
Thank you.
Okay. Anything else?
Yes, Your Honor. This is Stephen Lee on behalf of Walmart. I apologize. I can't start my video. It says that the host has stopped it.
Oh, yes. Yeah, I can do that. Hang on.
Shouldn't be an issue. I just have a point of clarification regarding the witness affidavits. Did I hear correctly? Another party's counsel mentioned that the PSC reference number to the testimony must be included in the affidavit.
That's our best practice. Yes. I believe that's how it's described in the FMO. I mean, I've certainly seen it done different ways, but that would be the way it's directed.
So the reason for my question is that if we have to file revised versions of the testimony that same day, I don't believe I'll have the PSC reference number for the witnesses to sign the affidavit, if that makes sense.
Yep, that you're correct. So I would wait till you get the reference numbers and then file the affidavit.
Okay, understood, Your Honor. Thank you.
Okay.
The verification affidavits, you had just indicated that you preferred PSC reference numbers included in those. And I apologize if I missed that somewhere in the facilitating matters order, but we actually already filed ours without PSC reference, but if that's, make a note of that, I guess, for the future, but
that's fine. Yeah, you should do that in the future. Yeah.
Thank you.
Okay, sorry about that. All right, is that it then? Okay, we're adjourned. Thanks very much.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
So
Thank-
Debbie, just put you were adjourned at the end.
Well, I just put, excuse me, I just put an interruption and then you just saying that's fine and you can,
Okay, all right.
I'm assuming that's okay.
Yeah, that's fine. I just, yeah, my connection just blew up, so I thought we were done, so I was thinking that would be it.
Oh, well, she was talking and then everybody stopped and waited for you to answer and then you
Oh.
stuck there.
Okay. All right.
So, and I found out it's my computer, it's not Zoom. It's my Zoom computer is, I don't know what's going on with my headphones, but it's all